instructed, the client has not come forward. There is a preemptive order, necessary order.
Your instruction, sir, it is compromised.
Yes.
But he has not. Land counsel for the petitioner on the last occasion submitted that the matter is compromised between the parties, and they'll come up with a joint memo in that regard. According to the same, this court has adjourned the matter on 21/10/2024 and made it clear that no further adjournments will be granted. Today, when the matter came up, Land counsel submits that they're not able to contact the party. No, they've informed the party, but they have not come up with a. They informed the party, but the party have not taken any steps considering the same. According to the fact that the matter is already compromised, the petition is dismissed as unpurchased. Yes, please.
Which time will be granted, my lordship? I will file that. Which time may be granted, my lordship? I will file it.
Non-filing of translated copy of evidence for defendant by advocate or petitioner as per order taken. Then counsel submits that during the course of the day, she will file the translated copy. This is matter on 21st.
My lordship, which
petitioner. Petitioner.
Where is the counsel for the respondent?
He's not here. He's not here. On both occasions, my lord, he has not here.
Please use the mic. You are not audible at all.
On both occasions, my lord, he has not present.
You have filed.
Yes, my lord, I have filed. Last occasion also.
In spite of an order passed for this court on 11/11/2021 and 22/10/2024, the respondent has not filed the affidavit before this court. Even on the last occasion also, there is no representation on behalf of the respondents. List this matter on 21 as part of 21st. Yes, next.
Fill number 4.
Respondent number 2 and 3 are proposed in our family court. They are the daughters. The order of the family court is they are entitled for maintenance till they attain age of majority. Both of them have attained age of majority. Now I have not arranged them as a party.
But like when causal is as it is should be, why should we leave the registry to be a judge, to be an advocate? Please do it. The office objection shall be complied with. A week's time is granted. And you can say that they are not necessary.
Not necessary. I have filed a memo, mother.
That should be the cost title should be as it is. Put a note below the cost title. Yes. So,
Please admit it, no. You may post it for timely.
why you can decide it at this stage itself? What is the so?
Liability, they have been filed.
But
the honorable file has judgment said that they are not filed. Should go on.
LCR is called for. No. History is directed to call for the LCR is there.
LCR call the student branch.
TCR received at TCR branch. Let the TCR be placed before the court. Place this matter on 25th. Yes, next.
Number 6. GST mark.
last petition, my lord, the Supreme Court had directly vacated the notice, my lord. However, my lord, later, my lord, trial court advocate has refused, my lord. Hence,
Has
my lord,
refused.
Refused. Hence, my lord, I have done a WhatsApp to his number, my lord. To that effect, my lord, I have produced a document also, my lord. Acknowledgement.
What is happening to the notice to the respondent?
My lord, it was, my lord, unserved, my lord. Even, my lord, my lord.
What is the postal sheriff?
Postal sheriff, my lord, unserved, my lord. And even, my lord, there, my lord, before trial court, my lord, in the month of March, in the interim order.
When is the matter coming up?
My lord, there, my lord, as there is interim order, my lord.
Stay of the proceedings.
Yes, my lord. In the month of March, my lord, interim order has been granted, my lord. You know the interim order, but however, my lord, is refusing. Where, my lord, in respect of.
No, in the docket proceedings that is recorded,
Yes, my lord, interim order has been recorded.
that you place before the court.
And, yes, yes.
That you place before the court.
And even, my lord, he is appearing before, my lord, I have filed miscellaneous maintenance, my lord. Where he is appearing before this court.
This court. What is the name of the advocate?
My lord, and,
Verify it and tell the court. We'll print his name. We'll see.
and yes. Also, my lord, whereas, my lord, here, my lord, he is ready to take, my lord. Just lordship order, lordship order. My lord.
It is submitted that in a criminal miscellaneous, the for the same party, the advocate is appearing. Petitioner shall serve the copy of the shall serve the notice on the advocate. Here you're saying in High Court or in
In the Dharwad, right, Dharwad, right.
shall serve the same on the advocate who is appearing for the very same party.
And
It is submitted that the counsel who is appearing in the MC has refused to receive the notice, and even on the same address, if even the notice is sent, it has come up, it is unserved with an it is returned with an endorsement unserved. Yes, this is matter on 26. Yes, next.
Meanwhile, interim order may be.
Intermodal granted is extended till then. Yes, next.
One submission, my lord. That is criminalness miscellaneous before Dharwad family court.
Dharwad family court.
Advocate.
Criminal misdemeanor. Yes.
So number 7, DP Karga.
I am filing memo for conversion of the RPFC into writ petition.
The present RPFC is filed, questioning an interim order passed by the court, passed by the family court, and the office has taken an objection. Now a memo is filed, seeking permission to convert the same into a writ petition. Accordingly, permission is granted. Petitioner shall convert the same within 1 week from today.
Madam, my lord, one submission. The paper may contribution to scrutiny immediately,
papers
so I will,
have returned to the court.
today only I will comply all these things. Matter is very urgent.
Yes.
Oblige, my lord.
Disposal for status of paper.
Uh,
Disposal.
yes, next.
So number 8, DP Murari. DP Murari.
There is an office section, serial number 5. That 5 is petitioners are not made as parties to RA number 135 of 2019. I sought for the transfer of RA number 135 of 2019 and 72 of 2023 to one and the same court. One is in the 3rd additional district judge court, another one is 4th additional district judge court at Dharwad. In that particular 135 of 2019, I was not a party. It arises out of FTP number 34 of 2013, my lord. In that particular, what has happened, that my party is one of the legal heirs, representing legal heirs of one of the original, the co-partners. See, they have been left out. And final decree was obtained. The decree was obtained. Final decree proceedings were initiated in 35 of 2013, my lord. In that particular case, after coming to know, I filed an application to impede me or otherwise allow me to contest that particular case. But that particular application was filed by my clients, these petitioners,
under section 152, 153 like this, for correction of that particular judgment. That was reflected only on the ground that I have to seek in a separate, in a separate suit. So therefore, I filed another suit, 61 of 2019, 2016, out of which that particular the OS came to be dismissed on the ground that I have not produced proper evidence. My evidence in that particular case is held up in that 34 of 2013 FTP, out of which this particular 135 arises. So therefore, I was not a party to that particular proceedings. So I have not made as a party. So only for 72 of 2023, I am a party. So this office of section may kindly be overruled. I have produced the appeal memos in both the cases, Annex A and C, and order sheets of both the courts, B and E.
So now the office objection is you are not a party to
Not
RA
a
number
party.
130 of 2019.
That is it.
So how it can be transferred?
Well,
How you can seek transfer of that?
Well, in that particular case, my evidence is there, and I am one of the party.
The office objection, considering this council submission, with regard to objection number 5, the office objection is overruled.
And there is one more office objection.
Yes.
If a separate has to be filed for a stay measure.
It has to be filed.
Separate,
IA has to be there for stay.
not that, affidavit has not been filed. It is in the form of this, in the petition. In the petition, we have made our mates, and affidavit is short
What
only.
is the procedure here? For every stay petition, there shall be an affidavit. I don't know what it is here.
Affidavit is there, my lord. But our mates, entire our mates are in the petition for stay. And affidavit is just like simple, like a writ petition, madam. That is the objection.
Please do it how it is supposed to be.
Yes, madam.
The office objection is serial number 9 shall be complied with
Yes, please.
within a period of 1 week from today.
Yes.
Yes.
Serial number 9, serial number 9, 59.
Notice. Yes, yes.
Serial number 10, page 1.
Mine,
Notice has to go.
R1, R3, something is, somebody is appearing.
No, R4 died, madam.
Oh, LR petition.
Please, madam. Notice.
There is a LR petition. I number. I number 2 is filed. To bring the LR so the deceased.
That was the there are supposed to.
Appellant number
No,
1.
no, it's supposed to be respond number 1. Mistake.
The deceased respondent number 4.
Four, madam.
4. This is number 4 on record as A4A and A4A and B. Notice to the respondents. Notice to the proposed. Issue notice to the proposed respondents. Yes, next.
Serial number 11,
Manos,
I have time.
Manos, we are required to file our assets and liabilities affidavit, Manos.
Why you are not filed?
Manos, the matter is most likely to be settled because today she is joining him. The respondent is joining her husband today. And the matter is posted for conciliation before the trial court today.
Trial court. It is submitted that the mediation talks are going on. List is marked on 3rd December.
Please.
3rd December, next.
Question number 2. 1 month.
Matter, my lord, section came to be dismissed for non-prosecution for non-compliance of office objections, my lord. We have complied, partly complied, my lord, but one or two are oversight they have left, my lord.
A week's time is granted to comply with the office objections, failing which petition shall stand dismissed.
We have, in the meantime, we have complied, my lord. Only one or two are due to oversight they have left out, my lord. That's all.
So, what is to be done now?
That's all for the recalling of the order, my lord, and the disposition.
First do it.
Please.
I 2 of 2024, if I'm recalling the order, dated so and so. In the meantime, pending consideration of the same, the petitioner shall comply with the office objections during the course of the day. Give it to him, the file. List this matter on 20th of November. Yes, next.
Question number 30.
Yes, this is a matter about
You have filed IA.
IN seeking direction to release.
Like counsel for the present petition is filed. Questioning where is that order?
Order at page number 30,
30?
36 now.
Huh?
36.
Page number 36.
Questioning the order dated where do you get the order date?
23 9.
23?
9.
23/9/2024, where the judicial custody
is extended.
Judicial custody he was remanded to judicial custody on 25/7/2024 till 23/8/2024 for a month. Thereafter, by order impugned, the court had extended the judicial custody for a month. When counsel for the petitioner relies on section 125.
That's what
CPC, CRPC.
and one more judgment of the
Relies on section oh, 125(3) that which says which may extend to 1 month or until payment may extend to 1 month until payment which is sooner made. Basing on this, when counsel submits that, the court has no jurisdiction to extend the remand. No, extend the remand. And for the last 3 months, the petitioner is in judicial remand, considering the submissions that they are answer the petitioner. The order dated 23/9/2024 is suspended. Issue notice.
again after this also my lords again remand has been made.
That's the latest order.
Yes.
That is the latest order, 23/9.
No, my lords. No, latest order.
That you have to question.
Sir, let me ask about
But still, last one.
Since I am seeking about the release of the petition in mentioned also and so.
It's very sad. But you have to question the last order. How can you not question it?
After filing this about petition about
You can file it also along with another document. Where is IA?
I is not fine. Again, it is extended to 3/12/2024 on 4/11/2024. It was extended to 3/12/2024.
Your expedition is on 227 or 226?
227. 227.
But your interim application is on 226.
The application is filed under 226.
What is that?
The inherent power of the court.
Huh?
Not so.
So now, while exercising 227 jurisdiction, inherent powers under 226 will be exercised.
I mean,
How can it be? No, considering the same, the family. Oh, you can't see these kind of reliefs. The order, once it is suspended, that order of remanding you, automatically you are entitled for a release, isn't it?
I am seeking only till the disposal of this petition.
That only, that the suspension will be till the disposal of this petition. Please frame that, file it after.
Possible.
Like a normal IA in a 227 petition. Yes. That let him file the order is accordingly the order dated. That order also you file.
Please.
That order it is submitted that subsequent to 26 or 24.
26.
24, I think. What is the order issued?
23 now. 23.
Thereafter, after the order passed on 23, another order is passed whereby the remand is again extended until the last 3 months he is in jail. Hence, the order dated so and so is suspended till the next date of hearing. That you file that order also, let it come in the afternoon.
Yes.
That order and stay petition also proper stay petition. Yes, next. Awesome.
Seal number for discussion, seal number 14, another day.
Respondent. Do that. This is a CRP of 2019. On 21/10/2024, at the request of non-counsel the petitioner, the matter was directly registered on 5/11/2024. That is, it has made it clear that no further adjournments will be granted. Again, on 5/11/2024, this court has directed the matter to be registered on 12/11/2024, and no further time will be granted. On 12/11/2024, as there is no representation, this matter was directed to be listed under the caption dismissal on 13/11/2024. Today, in the matter is called up. The counsel respondent is present. No representation for the petitioner. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes.
Seal number 15, seal number
Matter numbers, no, the matter is in trial, before the trial for this set out for defendant evidence, my lords. Whether it survives or not, I seek instruction, my lords, it may be taken after.
Tuesday.
After 1 week.
Why? To find out, you require 1 week.
Please.
List this matter on 22nd. No
Please.
further adjournments.
Please.
At the request of non-counsel, the petitioner delete from the caption or dismissal.
Please.
Next.
seal number 16. Deepak S. Kulkarni, seal number 16.
submitted that the petitioner has taken no objection and entire records are given to the petitioner. And the council submitted that will come up with appropriate application. Then again on 12/11/2024, also there is no representation. If a matter is directed to be listed for dismissal, the council, having taken no objection from the council, the petitioner, having taken no objection from the council, has not taken any steps to engage another advocate. Considering all this, it appears that the petition is not interested to pursue the matter, accordingly dismissed the non-prosecution.
Syllabus 17 until syllabus 18. Is the correct English category?
10 days, 5 minutes to complete the office objection.
What are the office objections? Why do you require 10 days?
File is missing, my lord. File is missing, my lord. File petition.
File is missing 2024.
Yes.
IA is filed under section 151 of CPC, praying to stay in so and so.
Husband petition.
It's coming up for admission, no office objection.
Next week, my lord, any day will take.
List is matter on 19th. No further adjournments will be granted. Read from the caption for dismissal. Yes, next.
Syllabus 9. Pushak Bhattapati.
My lord, petitioner seeks transfer of the original suit number 28 seeking restitution, currently pending before the family court in Dharwad to the family court in Belgaum. My lord, petitioner is currently residing with a father who is 70 years old and has no means of livelihood and who needs constant care and medical attention.
Who is for?
Seeking restitution of conjugal rights.
What is the distance between the two places?
My lords, she lives in Belgaum, my lords, and the respondent and his 4 brothers are constantly intimidating and threatening her from entering Dharwad. And until recently, I had my kids with me, but on the pretext of celebrating Eid, they were taken away from me, and I'm told that they are now being employed in this puncture shop in Dharwad.
No. This is a case where it is told that the children are with the father.
Until recently, they were with me only, my lord. I separated from my matrimonial home along with my children. But until recently, the respondent's brother has taken
Whatever the stand as of now is, children are with the father. Father has to take care of them.
From 21, my lord, the children are with the father.
My lords, I was told that they'll celebrate Eid and they'll be back.
Let your client file an affidavit before the court stating that till what time the kids were with them. And tell her, let her be careful in filing an affidavit. Then counsel the petition submits that recently the father has taken away the children and they are with her. And then counsel appearing for the respondent says submits that right from 2021 they are with the father. In that regard, an affidavit shall be filed before this court. This is matter on 27th.
27.
Please,
28th, my lord.
Huh?
28th, my lord.
28.
Please, sir.
Yes.
Order matter syllabus 30. Amatal Sauka. Are you satisfied?
Sir, first question it was argued, ma'am, with regard to the landed properties, suit is undervalued. Preliminary issue raised. Trial court rejected our contention, holding that suit is properly valued. The last occasion I argued, and the Lord's cause asked the other side, what document you have produced to show the valuation
Of the house property.
house property. That is it. And the Lordship was of the opinion that it is to be remanded to the trial.
It is his case that my lords I have undervalued. I am claiming half share in 1/4 share.
No. Forgetting about what is his claim.
Yes.
Now, court fee has to be paid, proper court fee. Now, for agriculture properties, you brought that
Yes.
the sub-registrar's value and shown. For this, whatever it is, there should be some basis for saying this is a court fees, basing on something that you should have done. Court should have looked into it.
Only to that extent, my lords.
And to that extent, we'll remand.
Please.
To that extent, we will remand. As far as your case is also that, you are also concerned about the
That house property.
house property.
No, they are producing.
You are relying on some decree and basing on that you submit.
Yes.
That we will negative that contention of yours. But as far as the other property is concerned, the residential property,
Yes.
that let him,
So I
let
will
the court.
produce a sub-register.
And based on that, let the court value it.
Please.
Yes, please come.
This order needs to be not set aside and
It has to be set
Yes.
aside as far as that extent is concerned.
Yes, sir. Only in respect of house.
House property. Agreed with the order passed in IN number
No, yeah.
on a
Preliminary issue number
preliminary
6.
issue on whether the court fees paid is sufficient or not.
No, no. Pecuniary jurisdiction.
Pecuniary jurisdiction
Page
of
30.
the court whether the court is having the pecuniary jurisdiction or not. Agreed with the order passed therein. The defendant is before this court.
Number 4.
Defendant number 4 is before this court.
Oh, sorry, 5.
5 is before this court. The respondent herein has filed respondent number
1 minute.
1. Herein has filed a suit seeking the relief of partition and separate portion. In the suit, the issues were framed, and the issue number 6, with regard to the pecuniary jurisdiction of the court, was treated as a preliminary issue. It is a case of the defendant that the suit scheduled properties are 9 landed properties situated at different villages, situated at Kuruvingkoppa and Hirekoppa, and 4 properties situated at Hirekoppa village, Gram Panchayat. The proposed trust has expired in the year 2009. His wife predeceased him in the year 2001. Both of them have left the defendant number 1 to 4 as legal heads. Out of the suit properties bearing survey number 56/2, 8 and 51/6 are the ancestral joint family properties of the deceased. The remaining properties, that is A and B properties, are the properties of deceased Lakshman Ramappa, and one of the suit properties bearing survey number 51/6 of Kuruvingkoppa village was purchased by the deceased.
No,
Correct.
sorry for it. This is a fact relating to earlier suit filed by,
No, that's what.
but present facts narrated in the present suit is.
No, that is relevant because basing on that suit filed partition,
Yes.
you are claiming that the suit value as on the day the property's value is so much.
Yes.
No, they have shown it less, isn't it?
Yes, yes.
So for that only I am narrating this. For that purpose,
Yes.
where that property for the
Same
purpose-
properties, no.
That's
Even
what.
extent also same thing.
For that only I am narrating this. Where is that? Survey number 51/6 was purchased by the deceased, not survey, it's not suit. Survey number 51/6 was purchased by the deceased for sale consideration of an amount of rupees 58,000. And after the death of Lakshman Ramappa and his wife, where is your application?
No application.
Or your stand? Where is that with regard to the earlier suit? Nothing has been stated anywhere. Nothing has been discussed with regard to the earlier suit valuation.
In the present judgment order, not discussed. Though I have produced the judgment and decree, court recorded the finding that I have not produced any document.
Where is that earlier suit number and all?
Yes,
Where
that-
from the court will get?
That is OS 149.
Where will the court get? Page number?
That is,
Allah, please. My lords may find it
Alex,
page
sir,
number 16. In the written statement, he has taken a contention that my lords suit is undervalued.
1/6.
Please. OS number 149 bar 2012. It is earlier, sir.
my stand in the earlier suit or in the present suit? No?
Earlier suit. Where is that?
Okay,
No,
please.
earlier suit, no, I have not disputed about the pecuniary jurisdiction.
It's not that. It is your case that earlier a suit is filed
Yes.
with regard to the very same property.
Same property.
And it's your case that as on the day, the properties are valued at so and so.
Yes.
No, they are undervalued.
Yes.
So what is the suit filed? Where are the averments?
The judgment copy is produced at OS 1,
Where
page
is that?
16.
Page number?
16, 16. OS 129 bar passed by the
Earlier, for the partition of the very same suit scheduled properties, OS number 149 of 2012 is filed. And the same is decreed by judgment and decree dated 29th March 2014. And it is held that the plaintiff is entitled to get 1/4 share in the suit scheduled properties, and the defendants are entitled for 1/4 share.
And FDP is also
And
filed.
in that, the properties, schedule A properties and the B properties were valued at 54,23,750 and 7,50,000. Now the present suit seeking partition.
No,
Yes.
being agreed by that order, he has preferred RSA before this order.
That we will go. So what is the present suit?
Present suit, no, the OS 23 of 13. For same seeking partition separate
No,
separate
filed by
possession.
the daughter of Ramesh.
Who is which defendant or plaintiff?
That defendant number 1 is, in that suit, he is defendant number 1.
Defendant number 1's daughter has filed the present suit seeking partition.
Partition in 1/4 share.
Seeking
That
partition
half-
in 1/4 share of
Half-
share which fell to her father's share.
Claiming half share.
Claiming half share in the 1/4 share which fell to his father. The petitioner before this court is a purchaser of the property from the father,
Father Ramesh.
from the father of the plaintiff. Now the grievance of the defendant is that in the year when the suit property is valued at a higher price, now the very same properties which are part of which are the suit scheduled properties, they were undervalued. It is submitted before this court that he has filed the order copy at the judgment and decree invoice number 149 of 2012 before the court to show that how the properties are valued. But in spite of the same, the court has failed to take into consideration. It is submitted that once the properties are properly valued, the court will not have the jurisdiction to entertain the suit. The counsel submits that the court, without any basis, without any discussion, had come to the conclusion that the suit is properly valued and that is within the pecuniary jurisdiction of the court without appreciation of the facts and the contentions. Next one. Learned counsel appearing for the respondent submits that as per the sub-registrar's value, the suit is valued.
Exhibit P1 and P2 I have produced.
Exhibit P1 and P2. And considering this, the court has rightly come to the conclusion that
Sorry, P43
P1 and
P1. Sir.
considering this, the court has come to the conclusion that the property is properly valued and it is within the pecuniary jurisdiction of the court. He submits that he is seeking only 1/2 share of the 1/4 share which is granted to the father of the plaintiff. Next part. Having heard the learned counsels on either side, peruse the material not recorded. The suit scheduled properties are property A and property B. Correct?
yes, please.
A scheduled properties are the landed properties. In respect of the landed properties, the petitioner has already produced the sub-registrar's value. Basing on the sub-registrar's value, the court has come to the conclusion that the suit is properly valued.
Respondent has produced. Respondent has produced, not petitioner.
The plaintiff had produced exhibit so and so, and basing on that, the court has come to the conclusion that the suit is properly valued. When this court has perused those documents that pertain to the landed properties, as far as the pre-scheduled property is concerned, which are the residential buildings,
Residential and open space.
residential and open space, in that there is no document placed before the court to show what is the value of those properties as per the sub-registrars, as per the register maintained with the sub-registrar. The trial court ought to have considered the said aspect. The order of the court as far as Schedule A properties are concerned, that holds court. But in respect to the B scheduled properties, the court needs to reconsider the same. Hence, in view of the above discussion, this court is passing the following order. The order impugned dated 5th March 2022, passed in voice number 23 of 20, passed on the preliminary issue in voice number 23 of 2013 on the file of the civil judge at JMFC.
No, 23 of 2013.
23 of 2013.
But in past title, they have made a mistake, 23.
So what is it?
13 is correct.
Can you see?
OS 13, 23.
OS 13 is correct.
13 is correct.
But in second page,
It is voice 13 of,
OS 23 of 13.
that's what I said.
But in next page, they have made here
No,
mistake,
but
23
voice
of-
number,
Please.
voice number 23 of 2013.
Please.
Date 15 March 2022, or the file of the civil judge JMFC Nagpur, is set aside as far as these scheduled properties are concerned. And as far as A scheduled properties, the valuation of the same holds good. Hence, the same is set aside and remanded back to the court below, and the court shall consider the same. And the parties are at liberty to adduce necessary evidence in that regard. Accordingly, the petitioners, the CRP is disposed of. Yes, next.
Number 20. We are standing open.
Day before yesterday, the lawsuits this sale deed of the year 1967, they are assessing up to 48 years, 2015 suit has been filed. Constructive notice not regarding the registered sale deed. Not,
Please appear for the response. What is and for the plaintiff, my lord, you also make page 28, the amendment that I have sought. Para 2B.
No, what is the suit for?
suit for declaration and possession. Sir. He claims that the father of defendant number 1, grandfather of defendant number 2 to 4 have executed registered sale deed in favor of the the defendant. Grandfather of the plaintiff has sold the property in favor of father of defendant number 1. In the year 1967.
By that time he is not even born.
Please, no?
The plaintiff-
by the time he was not on board. And he claims that by virtue of registered sale deed, our names have, my father's name has been entered, and after death, our names have been entered. And now saying that that sale deed is bogus sale deed, and declare him as the owner of the property. So, my lord, I filed he filed an amendment application seeking possession, my lord. This honorable court, by virtue of an order saying that this amendment will come
From the date of
from the date
application.
of the application. And I filed an application seeking rejection, my lord. I read over the application. So, your lordship may kindly see page 50, application, my lord, affidavit. I relied upon two decisions, my lord, rejecting the plaint considering the registered, my lord, document.
Declaration that the plaintiff is the absolute owner of the suit property
And for possession.
and for possession.
Yes, please.
Consequential relief of injunction to be issued against the so and so. You filed a petition under order 7 to 11.
Yes, my lord.
On the ground that?
My lord, page 50, my lord.
Page 50.
Affidavit correct 3.
Yes.
I state and submit that initially the plaintiff instituted suit on 14/8/2015 seeking a declaration that they are the absolute owners of the suit property and consequential relief of injunction. On perusal of the entire claim, it is the case of the plaintiff that the defendants have illegally got entered their name in the record of rights by virtue of registered sale deed dated 3/6/1967 and in para 2
When your names were
immediately after the
right from 1967.
1967. And in para 2C of the plaintiff, it is contention of the plaintiff that the state sale deed is illegal and void and also sought for prayer for possession. At the first instance, the plaintiffs are assailing the sale deed of the year 67 in the year 2015, and the possession is sought by virtue of amendment dated 1/2/2020. This honorable court in WP 10007 has passed a specific order in terms of section 21 of the Limitation Act with the amendment incorporating the relief of possession and assailing the sale deed shall not relate back to the date of filing suit, but the same shall be reckoned from the date of filing of the application. Insofar as the relief of declaration assailing the sale deed of the year 67, the suit is one on their eyes is hopelessly barred by of limitation. Insofar as relief of possession is concerned, even assuming but not admitting the cause of action shown in the original plaint, since the amendment seeking possession is sought in the year 2020, the same is also issued by Article 68 of the Limitation Act. Or Rule 11B of CPC provides that the claim can be rejected if the same is barred by any law. Honorable Apex Court in the case of Bargari construction reported in so and so.
They are not sought that the sale deed is not binding on them?
In the plaint paragraph, see,
prayer.
Prayerly, he says that we be declared as owner of the property and possession is sought.
Then what will happen to the sale deed?
Please.
What will happen to the sale deed?
Sale deed remains. Sale deed remains, but if he is on the very contention of the plaint paragraph are produced, the plaint is tactfully drafted saying that the para 2A he says that the sale deed is bogus and it is not valid.
And you were relying on some judgments.
Yes, Lord, two decisions.
No, this is a difficulty for the court.
Yes,
Every
Lord.
time the matter is
Yes.
adjourned, again everything has to be started
Yes,
afresh.
Lord, yes.
So what is this Justice Srinivas Harishkumar judgment? You are relying on which paragraph?
Yes, yes.
With regard to this constructive notice?
No, Lord, the cause of action, Lord, 11.
6. Para 6.
Para 6. Lord, the para 8 is relevant, Lord.
Para number?
Para number 8, Lord. As regards limitation, in para 38 of the plaint, it is clearly stated that the cause of action arose on so and so. Is that when the first defendant executed a sale deed in favor of third defendant. That means the cause of action first arose on 18/3/2005. This is a suit for declaration and possession. Just because possession is claimed, 12 years period of limitation is not available. Unless the sale deeds are set aside and the plaintiff rightly declared, they are not entitled to possession. Declaration is the main case in the circumstances period. Article 58 of the limitation is applied, therefore limitation is to be reckoned from the first date. The subsequent dates period do not extend the period of limitation. In case of so and so, it is held. While enacting Article 58 of 63 Act, the legislature has designedly made a departure from the language of.
Yes, what about the next step?
Next judgment,
Which para?
please.
This is with regard to the constructor notice.
Yes, please.
Para number?
Please. Uh, Page 49, para 16, answer to point number 2. Whether the registration of JD in respect of a lease joint family property would amount to constructive notice to all. Para 16.2 and 16.3. And para 16.6. Mary covered 16.2. The registration of a document makes it a public document, and such registration is also reflected in the encumbrance certificate relating to said property, thereby indicating that there is an encumbrance created. Constructive notice is a notice which treats a person who ought to have known a fact as if he actually does know it. It is the knowledge which the court imputes to a person upon legal presumption so strong that it cannot be allowed to be rebutted that knowledge must have been obtained by the person had he made all the relevant inquiries. In terms of explanation 1 to section 3 of Act Transfer of Property, if a transaction relating to the immobile property needs to be effected by a registered instrument under law, then the registration of the document will be deemed as a constructive notice. Based on that, my lord, will also
55, page 55.
Yes.
16.6.
Yes.
And 16.8 also.
Yes.
Relevant. Yes.
And my lord, subsequently, my lord.
So according to you, the suit is barred by limitation.
Yes, yes. And para 18 it is held that it is barred by limitation. And another judgment, my lord, I am going for. The judgment of Honorable Apex Court, my lord, in 2000 SAR, my lord. 2019, my lord. SAR C484. You also may kindly come to para 6.1, page 487. At the outset, it is required to be noted that the plaintiff has instituted the suit against the defendant for declaration that the defendant has acquired no title and possession on the basis of a deed of gift dated 6/3/1981, and the plaintiff has got title and possession in the said property. In the suit, the plaintiff has paid for the following reliefs. Lord, to be declared that this deed of gift dated is not binding, possession of the plaintiff be continued. And your lordship may kindly come to para 7, my lord, in page 490. Applying the law laid down, my lord. Your lordship got applying the law laid down by this court in the aforesaid decision on the exercise of power under order 7 to 11 of CPC to the facts of the case on hand and the averments in the plaint, we are of the opinion that both courts below have materially erred in not rejecting the plaint in the exercise of power under order 7 to 11 of CPC. It is required to be noted that it is not in dispute that the gift deed was executed by original plaintiff himself along with his brother. Deed of gift was a registered gift deed. The execution of a gift deed is not disputed by the plaintiff. It is the case of the plaintiff that the gift deed was a survey deed of gift and therefore same is not binding on. However, it is required to be noted that for approximately 22 years, neither the plaintiff nor his brother claimed at any point of time that the gift deed was survey deed of gift. One of the executants of the gift deed, brother of the plaintiff, during his lifetime never claimed that the gift deed was a survey deed of gift. It was the appellant hearing, original defendant, who filed suit in year 2001 for partition and said suit was filed against his brothers, to which the plaintiff was claimed as defendant number 10. It appears that the summon of the suit filed by the defendant is was served upon the defendant 10. Plaintiff hearing in the year 2000 itself, despite saying he instituted the present suit in the year 2003, given from the amendments in the plaint, it appears that during these 22 years, the period from 1981 till 2001-3, the suit property was mortgaged by the plaintiff hearing the original defendant and mortgage deed was executed by defendant. Therefore, considering the amendments in the plaint and the bundle of facts stated in the plaint, we are of the opinion that by clever drafting, the plaintiff has right to bring the suit within the period of limitation, which otherwise is barred by law of limitation. Therefore, considering the decision of this court in the case of T.R. Supra and others as with the law, as suit is clearly barred by law of limitation, the plaintiff is required to be rejected in exercise of power and process.
Yes.
Lord,
certain facts that are being now just put before this court are not accurate.
Are not?
Are not accurate. They are incorrect. I will take your lordship to the page 28 of the claim. But it is stated before this court that it is an admitted fact in the claim that back in the year 1965, sale was in fact executed by my predecessors, and that is an admitted fact. That was the.
It's not about admitted fact. A registered sale deed of 1965 is there or not?
Yes, they have relied on judgment of
Not the
constructive
judgment.
notice.
65 sale deed is there or not?
65 sale deed is there, but that.
Registered sale deed is there.
Yes.
No,
But
either
it is
you
not
have
with respect to my property, and my predecessors were not signed. That is my lord, page 28. What is
come
the
to the page.
Yes.
Page number.
Page 28, your lordship, may kindly.
Let's read your plaint and the whole plaint so that we'll understand. Page number.
Page 28 is the amendment, my lord. The first paragraph starts from page 27. May I read? The suit was previously standing in the suit property was previously standing in the name of grandfather of the plaintiffs, Hanumantappa Rayappa Lagli, and the father of plaintiffs, that is Siddhappa Lagli. Hence, the suit property was and is the ancestral property of the family, plaintiff's family. The suit land is an agricultural landed property, and it was not at all converted into non-agricultural land at any point of time. Since the date of ancestors of the plaintiffs are in possession of the and cultivation and enjoyment of the suit land till today. The plaintiff's ancestors have constructed a residential house in the suit land, and the plaintiffs are residing in the said house, and the plaintiffs have took electric connection to the house and paying electric charges regularly. The plaintiffs are paying necessary house tax also. Alternatively, the plaintiffs are in possession of the suit property.
No, if you are in possession of the property, why are you seeking?
It is an alternative relief. It's an alternative relief because in the written statement they have set up that they have registered.
You can, it's suicidal one. How can you ask for an alternative prayer when you are asserting that you are in possession of the property?
Yes, I will permit you. Yes, for the amendmental aim, what I have sought, I may permit it to you. It is submitted that the suit property is a Hindu joint family property of the plaintiff's family, and the suit property has fallen to the share of grandfather of the plaintiff, Hanumantappa Lagli, and the partition took in the year 1935 between their brothers, namely Ningappa, Rayappa, and so as per the partition, ME number 670 came to be effected in the name of grandfather of the plaintiff, Hanumantappa Lagli, was entered into R of the suit property on behalf of joint family. In the year 1962, the grandfather of the plaintiff transferred the area measuring west 30 molar and north-south 25 molar, that is 2 guntas on the northern side, in favor of Basappa Yallappa Ganga Reddy for the consideration of 100 rupees under a registered sale deed dated 19, and the very same possession of the above mentioned land is also delivered to in the presence of witness. This is not the sale deed concern. Para 2B. Further, it is submitted that the grandfather of the plaintiff, this is very important. Further, it is submitted the grandfather of the plaintiff by name Hanumantappa Rayappa Lagli and his elderly son by Hanumantappa are illiterate and rustic village persons, and also they are not educated and not knowing regarding writing and taking undue advantage of this fact. In the year 1967, the father of dependent number 1 and grandfather of dependent 2 to 5 by name Nilappa, Nangappa, Sarni and Sannaki and scribe and witness of fraud created a false and fabricated document styled as sale deed in favor of Nilappa, Ningappa, Sannaki. On going through the sale deed document, it was specifically mentioned and written that non-agricultural land of the suit property. Suit is never non-agriculture. It is an agricultural land. We have constructed a house. We are residing in that. It's a fabricated document. On going through the sale deed document, it was specifically mentioned. Moreover, the suit property in question till today is an agricultural land. It was not at all converted into non-agricultural land till today, and there is no any order or notation entry available to show that suit property in question is converted into non-agricultural land. Question of execution of alleged sale deed by ancestors of the plaintiff in favor of Mrs. Ningappa Sannaki does not arise at all.
Then in that case, you have to question this sale deed.
Lord, non-executing members of a joint family need not.
There are two things. Non-executing member need not seek for cancellation.
But not binding. It is not binding on them. It is not binding on them. Non-executing joint family members. My apologies.
If you are not an executant to the document, you need not seek for cancellation.
Yes.
But you should say that the document is not binding on you. There should be a declaration to that effect.
Lord, in my humble submission, I will convince your lordship further. I will also cite a few judgments before this court.
There is a judgment of Justice Bopanna, Justice Ravindran in the such way.
Lord, if I am a party to the registered document, I necessarily have to seek cancellation.
Cancellation
If
if
I am
you are
not,
not,
if I am a member of joint family, I will convince.
if you are not, you should at least say that it is not binding on you.
Right, my lord, it is document itself, further credential, I demonstrate. The document itself is a void document, is my contention. When the document itself is void, there is no requirement of formal declaration. I will convince the lordship, further. May I read further?
He admits that the father of dependent number one and the grandfather of dependent number two, 2 to 4 have purchased the property.
This is, my lord, this argument, my humble submission. This argument was already urged before this court in the earlier round of litigation. I will demonstrate. This honorable court has already in the writ petition held that this issue has to be decided at the final disposal stage. I'll take the lordship to the exact order also. May I read further? Look, salary by ancestors of the plaintiffs in favor of Mrs. Neelappa does not arise at all. Therefore, it is clearly goes to show that the alleged and illegal so-called style as salary in favor of Mrs. Neelappa Sanaki is a false, fabricated and concocted one. The contents of the title alleged and illegal.
So, according to you, basing on this, according to you, just because it is not converted into a non-agricultural land and it is termed as a non-agricultural land, that's why saying it is a concorded one.
No, that is what I am reading. The next paragraph. My predecessors have not signed, that is my contention. My contention is my predecessors have not at all signed this document. It is not my document, and that is the contention.
Your predecessors have questioned it any time?
No, my predecessors were illiterate persons. They never went before the sub-registrar and put the signature. This document came into the light only after I filed the suit. Therefore, only upon coming to the know, that is filed. The lordship last 4 lines of the plaintiff. Yes. Moreover, they have not put, whether their signature is there or not, that is required to be filled. Moreover, they have also not put any signature or thumb on the above mentioned alleged document. The signature and thumb of the above mentioned alleged document are not belongs to grandfather of the plaintiff.
Your grandfather is alive?
Yes.
When did he tell you that it is not that he has not put the signature?
He did not tell no, because he put forth the salary for the first time in the suit. I cannot be aware of a document which I never executed.
You have not executed?
My grandfather.
Where is your grandfather?
My predecessor.
When did he tell you?
No, he did not tell me because he was not aware. That is my contention. In the last 4 lines.
That's what I am saying. But there is a registered document which is the public document.
Yes, the judgment that they have relied is, my lord, in my humble submission, is overruled judgment. It cannot be relied. CRP judgment, my lord, is a registered document. It amounts to public notice and transfer of property. That judgment is overruled by the Supreme Court. This very judgment is overruled. I'll take the lordship to the various judgments also.
Yes.
It's an overruled judgment. The signature and thumb impression alleged document are not.
Even section 3 of transfer of property is also now not there in the statute book.
It is there.
It is there.
It is not my contention that it is, my lord, on knowledge. Section 68 of the limitation. Knowledge, my lord, it has to be pleaded, and whether I have the knowledge at the time of the filing of the suit or not, the suit is a matter for.
Yes, it's pleaded.
Because, my lord, just by the reading of the plain governments, I never pleaded that I had knowledge. Lordship kindly appreciate. I never had the knowledge. Last, signature and thumb of the above mentioned alleged document are not belongs to the grandfather of the plaintiff by name Hanmantappa and his elder the name Hanmantappa Lagui. Hence, the alleged document alleged to have been bought executed by father of dependent number and grandfather by name Nilappa Nilappa Sanaki from the grandfather of plaintiff by name Hanmantappa Rayappa Lagui and his elder son Hanmantappa illegal, void ab initio, not binding. Void ab initio and the same is not binding upon the plaintiff and his family members. On the basis of the alleged illegal above mentioned document in respect of the suit property, neither father of the dependent number 1 or grandfather of number 2 to 4 by name Nilappa Ningappa Sanaki during his life after his death, the present dependents and their family members have any legal valid lawful right, title or interest of the suit property, and also they have not at all came in possession of the suit property at any point of time. The ancestors of the plaintiffs have also constructed a house about 80 years back. They have also resided in the suit property. Now, my lord, after filing the suit, next paragraph, I'll argue for this. Next paragraph. This amendment, my lord, was sought in the year 2021. Now they challenged this amendment before this honorable court. And this honorable court, my lord, this very contention was taken up before this honorable court, page 46. So this very contention was taken up before this court, saying that the amendment could not be allowed at all because it is barred by limitation. Amendment cannot be allowed at all; it is barred by limitation, and therefore it cannot be considered under. That was the writ petition. And this honorable court.
No, in your order 6 rule 17 or a different aspect.
Yes. Yes. Last observation of this honorable court, page 47.
That is from the date of your petition.
No. There is another observation. Page 47. Married. Page 47.
Yes.
Impugned order dated 22/12.
Yes.
Impugned order dated 22/12/2022 is impugned order set aside. Liberty is reserved with the respondents and defendants to file additional written statement to the amended claim. I am reading at page 47. All rival contentions with regard to the amending of the claim as well as other questions including the limitation, maintainability of the suit, etc. are kept open to be adjudicated at the time of final disposal of the suit. So this argument was already heard.
Court cannot decide in an application under order 6 rule 17. Court will not decide the other issues.
Only
even if it is, even if for any of it or the kind of observation, how can the court say limitation and other things you do that? What in a revision, the scope of a revision is what is there before the court. What is there before the court?
This was not revision. This was not revision. Amendment challenge. This amendment was challenged on the ground of limitation.
Jurisdiction of the court under 227 or 115 or whatever it is. No, when that's a particular application order 6 rule 17, the court will decide only that. Court cannot pass something like whether they can question whether any order 7 or rule 11 application is maintainable or not.
No, I'm not on that. My contention.
This observation cannot be taken seriously at all because that's not the scope of the petition.
Yes, my submission, this argument was addressed before this court earlier on.
That's what I'm saying. That application is altogether a different application.
It's altogether
amendment can be, if it is before commencement of the trial, whether you have already laid your foundation for these proceedings, all
No, in fact, in the writ petition, this petition, it was specifically averred, and it was specifically contended and argued that the amendment cannot be allowed because of the fact that it is barred by limitation. Limitation was extensively argued in this. It was extensively argued, and this court was not convinced.
Please understand, let that court give 100 findings. That's a different issue. What is there before this court? This court will not consider what the other court said, which is nothing to do with the issue in controversy before this court. So let's not go to it. That order of order 7 rule 11 that both of you have succeeded, it has attained finality. Let's not go to it. Now we are on the application under order 7 rule 11. Now you have to convince the court that as placed by them, that you have known that section 3 of the Transfer of Property Act has no application to the facts of this case. And you need not question, you can't even ask for a declaration that it is not binding on you. And you have then it is not barred by limitation. Only 3 aspects you have to argue. Yes.
No, my lord, judgments, my lord, I will bring for judgment because the judgments are not fair.
See, how many
I am not,
please understand. This court cannot hear. I'm wasting already half an hour time is wasted on this. Again, the other day we have to start everything again. And this is second time.
I'm requesting for
you only, this is adjourned on the other day. So every time advocate gets a new judgment, you want to time on that.
No, these copies are not, no, sir.
That day it was there. You argued on that day. You were there.
No, it was not, sir.
You should have asked him.
No, I asked him.
Please understand, you people are wasting the court's time. I would have disposed some other matters. Again, I have to hear everything on the other day. This is matter on 20th as part of. No further adjournments will be granted, and no adjournments argument on your side. You let him submit on that day and we'll pass orders.
Submit one point and only one. In para 2C, he says that after all the it is submitted that on the basis of alleged and illegal.
No, the plaint is what the kind of the way the plaint is drafted. Their own contentions are contrary to what they are saying. It's like.
My name has been entered pursuant to the registered field.
No, that is. Let's see. Yes, next.
Still number 22.
At the request of legal counsel, the respondent lists this matter on 20th for the purpose of submitting the citations and argument of the counsel for the respondent. Yes.
Still number 20. Petition for no response.
Tomorrow.
Yes.
Tomorrow.
Why?
It's nearly out of session.
The request of legal counsel for the petitioner lists this matter on 27th.
27. Still number 23. Executive Secretary. Finish my mind.
Petitioner number wife. And 2 and 3 are the children of the respondent and petitioner.
What is, how much is the maintenance granted?
Lordship, 15,000 rupees per each. 15,000 rupees per each.
15,000 per each. How many are there? 3.
Lordship.
3 people.
3 people.
45,000 is granted.
No, Lordship. First petitioner is dismissed against the first petitioner.
Wife it is dismissed.
Yes.
Both the children how much?
It's over 1,000 rupees.
Huh?
1,000 rupees per month.
That is 2,000. 2,000 for both the children. For the wife it is dismissed. So you are for enhancement of the children or only on
enhancement and
why the court had dismissed your petition?
on the ground. The petitioners have not produced any documentary evidence to prove the in page number 18 of the judgment in page 18. And this ground melody is denied. And the result of the cross examination.
In the case on hand, the marriage to the first petition, read from C.
That on the case.
What is this inquiry by the court? It is something unwarranted. Court gives a finding that had she been as humiliated or harassed, she would have given a complaint.
But not only that, she has that same very referred in the cross examination that even the respondent is ready to take her medal, she is not here.
She has her own reasons. Her valid reasons are that she has been harassed. Who is the court to say that you stay with the husband?
Has she been harassed, madam? They should have similar complaint. Nothing on record to show that she has been harassed.
You want her to give now? So, in every case, unless and until a 498A complaint is given, then she is not entitled for maintenance under 125.
My lord, she said, the herself said in the evidence that
This inquiry under 125 is very limited, not to this level, as if they're finding out whether there is harassment or not. How can the court do all this?
But she cannot refuse without reasonable excuse, my lord.
She can have her own reasonable excuse. What is right from you may not be right for her. Court cannot always look at from one angle. What are the differences between two persons to live separately? They can't be like on this kind of beyond reasonable doubt. If the court starts, looking at this, then nobody will get the courts cannot grant maintenance.
But my lord, trial court, my lord,
This exercise court cannot appreciate. Yes. What is your income? What is your income?
My lord, he is an agriculturist. He has filed affidavit, he has filed his declaration before the trial. He has no property except the 4 acres of land in the name of his father.
What is the income deriving? It is deriving out of that?
Out of he is cultivating my lord 4 acres of land of his father, not his name.
Entire property is in the name of vide, nucleus family. 4 acre fertile land and 18 acres is the petitioner in her evidence, the producer document.
Give 2,000 to the wife.
I have filed a declaration.
2,000 to the wife, 1,000 to the children.
Only children may be considered, my lord, not wife, because they are directly where he has accused that even respondent is ready to take her, he is not ready. Even respondent need not look after my children also. He has said directly in the evidence. He is not necessary for me. And my lord, he also mentioned this Vidrugoda, one company is with him. My lord, this petition has been drafted in the year 2018, but filed in 2021. Why? There should be some relation. We should say that he is somehow related to me. Nothing.
Then we will make it that 1,000 given to them as 3-3. It will become 6. We'll reject the wife's case.
Please.
We'll grant 6,000.
Please not to consider this.
Ultimately, you will get it. We'll grant. Now, 1-1 is granted by the court. We'll make it 3-3 to the 3 to both the children. However, in whatever way.
Now the petitioner is residing at her native. It comes to district place. The distance between that place and district place is 3 kilometers distance.
So
the daily basis, day-to-day expenses is very high nowadays.
No, I didn't get you. What is that?
The present petitioners are lived in the parental house. The distance between that place and district place, Haveri, only 3 kilometers distance. And day-to-day expenses are very high nowadays.
Oh, because it is very close to the district place, according to you, the expenses are high. And then go away from that place. Please come.
5,000.
Now you're getting 6,000, what 5? Court said 3 for both the children. You will get 6. Court has granted 1-1. So now it is like court is granting 2 to all the 3. You should. Ultimately, he has to pay. You have to look at his pocket.
Your Lordship, he is welfare, Your Lordship, able to maintain the wife and.
Where is evidence? Where is evidence?
She produced a document, Your Lordship.
No, agricultural income, for example, if the court is granting how much? 6,000. Per year it is how much? That is almost 72,000 or 75,000. How much in what would be his income out of that 4 acres of land?
No, total 18 acres land is one and 4 acres fertile land is one.
You are having 18 acres of land.
I have filed a declaration.
Please give that statement of evidence.
And further 1 acre land in the name of the respondent father.
That also you want?
The exhibit P11 is also. Only P11 is also. In the name of his father. Manjunath Guru Basappa Angadi, 1 acre is also. And 4 acre fertile land also in the name of the respondent father is also.
Where did you say about your assets?
Exhibit P7 is also.
Where are your assets?
No, sir, no assets are in my name. All these assets are in the name of my father. No, actually, there no document is
His family is joint family now also is also.
Please tell the court what are the properties in his name.
His name is not property.
No properties
His
are
father
there.
name is.
How many children are there?
The respondent and his sister also.
So in the
parents
in the name of the parents, how much is the land?
4 acre, 1 acre.
5 acres.
And further your also. So another document.
5 acres divided by 3, how much? 5 acres divided by 3. How much you'll get the income? Please come.
I have 2 sisters and my parents.
Agreed with the orders passed in criminal misdemeanors number 111 of 2021 dated 16th of September 2022. The petition is before this court. The petition herein and filed a petition under section 125 CRPC seeking maintenance of an amount of 50,000 each per month to Hudson and to her 2 children. It is a case that the husband has had harassed her and had failed to maintain her. And she's staying along with her parent at her parents' house, and she's entitled for, and the husband is having landed properties, and is having the sufficient income to maintain himself, and to sufficient income to maintain the family. Hence, and she sought for the maintenance. The trial court had dismissed the application filed by the wife, wherein the court had extensively considered the fact that that the wife, without a reasonable cause, is staying away from the husband. Then, when it comes to the children, the court has observed that the petitioners have claimed maintenance of rupees 50,000 each. The second and third petitioners are residing at the residence of their maternal grandparents. As such, they do not require any amount towards accommodation. By looking into the cost of living and status of the parties, it can be concluded that the second and third petitioners, that the other children are entitled for maintenance amount of rupees 1,000 per month, apart from educational expenses. And accordingly ordered the petition. Next para. When counsel appearing for the petition submits that the court had failed to grant maintenance to the wife, and the maintenance of 1,000 each granted to the children is on the lower side. It is submitted that the wife cannot maintain the children at 2,000, and without maintenance she cannot maintain herself. Then counsel submits that to find out whether the wife is staying away from the husband without a reasonable cause. The court had conducted the roving inquiry, which is not required in a petition filed under section 125 CRPC. It is submitted that the husband is having, the joint family is having landed properties, agricultural lands of an extent of 5 acres, and they are having sufficient means only for the purpose of not paying the maintenance, purpose of evading the maintenance. He has come up with a story that he is not having sufficient means. Next para. When counsel appearing for the respondent husband submits that the court considering the evidence on record, and particularly the fact that without a reasonable cause, the wife is staying away from the family, court had rightly held that the wife is not entitled for maintenance. He submits that he's completely dependent upon his parents and is not having any job nor any properties. And the court had granted an amount of rupees 1,000 each, and there are no grounds to interfere with the same. Next para. Having heard the counsels on either side, produce a material on record. As far as entitlement of the wife is concerned, considering the manner in which the court had, considering the decision that is made, basing on the evidence on record, this court is of the view that the court has rightly held that the wife is not entitled for maintenance. Then coming to the children, the court had granted only an amount of rupees 1,000, which is on the lower side, considering the fact that there are agricultural land belonging to the joint family and this court is of the view that the amount of maintenance that is granted to the children needs to be enhanced. Accordingly, this court is passing the following order. 5,000 each. Court is passing the following order. The amount of maintenance granted in favor of the both children is enhanced from 1,000 to 3,000 each. That is, total is 6,000. The application as far as the wife is concerned, the case of the wife is concerned, the order of the trial court is upheld accordingly. Disposal. Next.
Will they attain majority or my lord?
Well, the court was so said so. They're only interested in such thing. Yes, next.
Number 24, Honorable Dissopa, Viranna.
Application was honorable challenge is not allowing the implementation of the petition. The petition by the husband was resigned to the post. Once he passed, when he has resigned, page 26 may continue when it was on the 21 January when he resigned. Petition is filed August 21. And
no, you have resigned the job.
Yes.
While you were in Dubai, Muscat, where you are working, Qatar, where you are working, and you have been sending the money to your parents' account, and basing on that, they have purchased the property, and you are having, that's their case.
No, not
that's their case. So, what shall happen to that?
No, trial court not has recorded anything on the source of.
That's why we'll ask them to record. Look at it.
Please.
Let the trial court look at all that. That's your petition. Your petition for how much is granted by the trial court?
Yes, the husband petition.
Only 10,000 is awarded, madam. We have asked for 30,000.
No, you have not sought for enhancement.
So far, because both the cases have been stayed here before the Supreme.
So where are the both cases?
My lord, as on that day I told you, my lord, before I made my submission before the Honorable Court, stating that parents and husband combining together made a conspiracy. Because
please understand, as far as this petition is concerned, it is filed by the husband questioning the maintenance granted by the family court at 10,000. No, you cannot have a say of any other thing, but only you can say that this order of 10,000 shall be maintained.
Not like that, my lord, because to establish a source of income, we have elicited the maximum information from him in his class examination. That's what I have filed this for. And also
I can understand. What I am saying is, this is a petition filed by him. In this petition, you cannot ask for any other things. Whether the court can only, you can say that the order passed by the court is correct.
We will file announcement there.
Huh?
We will file announcement there subsequently.
Where?
In trial court.
If you want to file. As far as this petition is concerned, we will see whether the 10,000 granted by the court is correct or not.
It's correct, my lord.
Argue.
Then, my lord, even, kindly,
Come to the order.
33, you got reasoning portion. Says 33.
32, para 32.
Yes. Where?
Para 32.
Please, sir.
Para 32 of the order.
No, 32 is not there, up to 8. Number
32. 32.
32. Totally 9 paragraphs are there. WP 102428.
My lord, I have filed that restitution of tangible rights. That has been.
What is that?
Additional copies.
That the document he has produced. He has produced that matrimonial case. Against that note, I filed 2 MFA. 2 MFAs are pending before this on court. One is restitution filed by her. And the impugned order under challenge now is at page 33.
Even execution petition is also filed there in the trial court. Even for that also is not responding.
Please read.
33, please. Para 8. It is not the case of the respondent husband that the petitioner is earning, nor does the dispute the relationship between himself and the petitioner. Admittedly, petitioner has been living separately for the last 4 years. The respondent husband, admittedly being an engineer, graduate in civil, has been jobless. The arguments of the statement of objections to indicate that the parents of the respondent husband having their own property, the respondent husband being the qualified.
Where is the consideration of the statement of assets and liabilities by the court?
Please.
Where is the consideration of statement of assets and liabilities of both the parties?
Oh, that is not filed, I think, in the event proceedings.
Why this is up?
Now
2021.
Now he is producing before this court.
Not before this court, before the trial court. Both of you are not done.
We are not appearing before trial court, we are appearing here only.
Not produced in the trial court. He has produced the affidavit of.
When the court is asking,
yes.
Have you filed means that is not the advocate, that is the party.
Parties, yes.
So what the party has done, you should be able to tell the court. So without assets or with assets and liabilities, if the court has decided it, please set aside this and both of you file your respective statement of assets and liabilities. Let the court decide the same.
Husband has filed. He has filed with a scanty material.
Please come. Agreed with the order passed. I number 2 in criminal misdemeanors number 168 of 2021, dated 24 June 2022. The husband is before this court. The wife had claimed has filed this petition under section 125 CRPC, seeking maintenance of an amount of rupees 30,000 per month. It is a case of the wife that husband has deserted her. No, because of the harassment. She is staying separately and the required maintenance. It is a case of the husband that the wife, without any reasonable cause, has left the matrimonial home. Because of the wife, he had to resign his job in Qatar in the month of March 2018.
21.
From the order I am reading, at page number 32, last paragraph.
Document
That he has resigned his job in the month of March 2018. That's what the court records at page 32 bottom.
Yes, ma'am.
In the month of March 2018. It is a case of his the petitioner that the wife had done her post-graduation with vide course and is capable of earning. The court observes that the wife is living separately from the last 4 years. Husband, admittedly being an engineering graduate in civil, is being jobless, and the respondent husband, parents have their own property. The respondent husband being a qualified civil engineer, and the petitioner wife being a postgraduate with vide course. She is entitled to lead her life after her marriage in a dignified manner, and accordingly directed the husband to pay an amount of rupees 10,000. Next para. The counsel appearing for the petitioner husband submits that the court, without any basis and without any evidence on record, and having considered the fact that he has left the job, had granted maintenance of an amount of rupees 10,000. Then counsel submits that the court had failed to consider the fact that the wife is double graduate and she can maintain herself, and she has a capacity to maintain herself. All these aspects were not considered by the court. Next one. Then counsel appearing for the respondent wife submits that the husband, while he was working in Qatar, he used to send all the amounts to the parents, and the parents have purchased the properties, and they're also having the bank balance. The husband had suppressed several facts, and he has not placed all the material and all the details as required by him as per the judgment of the Honorable Apex Court in Rashnish versus Neha. Next paragraph. Having heard the counsels on either side, that is the Richard Contact Court. The order that is passed by the court is bereft of any reasons. While the court had granted 10,000, there is no basis for it. The court observes that the wife has done her BA, her post-graduation with BEd course, and she requires to lead a dignified life. There is no discussion about why the wife is not working and about the assets of the husband or the financial capacity of the husband to pay the maintenance. While granting maintenance, the court ought to have a balanced view, taking into consideration both the case of the husband and the wife. Considering all this, the court is passing the following order.
My lord, sorry for the interruption. Since she is postgraduate, she is capable of making her own living out of her home. So, my lord, the present workforce needs a lot of skill and its own standard of conducting the things in the concerned unit where she has been employed. The Apex Court, my lord, in Sunita Kachwa versus Anil Kachwa, reported in 2014.
That you will argue before the trial court on this judgment. This court is passing the following order. The order impugned is set aside, and the matter is remanded to the trial court to the family court for fresh consideration. Next paragraph. Within 1 week from the date of receipt of the copy of the order, both the parties shall file their respective statement of assets and liabilities as per the judgment of the Honorable Apex Court in Rashnish versus Neha. Next.
I have already filed this.
What is that for your file? All your income tax, the prior to, as not just like passing that, whatever the Honorable Apex Court has
Yes, everything is.
So file it, if the parties have not filed, they shall file. If they have filed, the court shall consider the same in accordance with law and shall dispose of the application for dispose of the same within a period of 4 months from the date of receipt of the copy of the order. Accordingly disposed of.
Ship said, whole matter itself not or the only application? Because the entire matter itself can be disposed of.
RPFC, we are concerned with only our maintenance matter.
No, RPFC only. It is against the interlocutory application, interim maintenance, not the final maintenance.
Then how the RPFC lies? What
No,
is
it's
it?
a expedition.
It's an expedition, the only this application. Interim application for maintenance shall be considered and within a month, and the order shall be passed within 4 months.
And Lordship said, BE, not BE, but BEd. She is the graduation of Bachelor of Education. Lordship said BE, will not.
Postgraduate with PhD. Yes.
The two is correspondence course, my lord.
Next. Yes.
Number 25. How you responded?
Yes. Please use the mic.
Lord, the wife maintenance petition came to be dismissed, Lord, on the ground that the wife could not establish the marital relationship, also on the ground that I could not demonstrate that I got divorced from the previous marriage, which are not seriously disputed. Lord.
Please come to page 26 and read.
Please. The petition number 1, Akshata, examined as PW1 deposed evidence that the respondent is a husband, petition number 2 is a daughter of a respondent. Her marriage solemnized with the respondent on so and so and Srimuka, and after the marriage, she joined the respondent at his native place at Mudapitri to lead marital life. The respondent was doing private work on not having proper work, and hence again she and respondent came to Uppadi. And both were working in a factory of respondent's uncle. Thereafter, respondent addicted to drinking habit and said Dean Chandra used to tell the respondent not to come to work in a drunken condition, but the respondent not heard the same, and hence respondent removed the work from the work, but she continued her work. After the respondent started torturing her to leave the job since she has removed from the work, and further the respondent every day started to abuse her, assault her, and demanded money. And one day, by picking up a quarrel with her, thrown out her from his house, and also demanded to bring 2 lakh from her parents. Then her mother came and advised the respondent, but he has not needed the advice of her mother. Thereafter, she and her mother approached the respondent's parents, uncle, aunt, auntie, and others, and at that time, the respondent picked up quarrel with her and forced her to give a divorce, but she told that she will not give a divorce, and she lead marital life with the respondent. Thereafter, the respondent assaulted her by holding her hair and also abused and assaulted her mother also. Then, parents of the respondent told that they will perform another marriage with the respondent. She sustained injuries and taken treatment in Dharwad hospital. And the next day, when she had gone to the house where she and respondent are residing, but the respondent already vacated the house by taking all items in advance amount. And when she called the respondent through phone, he told that he left the house and she may do anything she wants. The respondent has not made any provisions for her maintenance. The petition number 2 is born from the marital relationship between her and the respondent. Then she approached the Mahila police station, but the police told that they will inquire the matter and had not taken the complaint. The police made phone call to respondent, but the respondent not came. Thereafter, she has given a complaint. The respondent is working as security and getting 13,000 to 15,000 per month. Further, the respondent has taken all the household articles, ornaments, and certificates until now not handed over to her. She is working as a computer teacher, getting a salary of 5,000 per month, but it is not sufficient for maintenance of herself and daughter. Now the petitioner is number 2 is studying in 6th standard in the Oriental School, and she has to spend 15,000 for school expenses and 5,000 for tuition and books. It is one prays to allow the petition as prayed in support of her. The exhibit P1 is the joint photo of petitioner and the respondent. The P2 and P3 are like other part of the petitioner. 1 is the exhibit P2 is the passbook of State Bank of India standing with the name. The exhibit P5 is the passbook of a Canara Bank standing with the joint names of a petitioner. 1 and 2. The petition, the exhibit P6 is a copy of a complaint given by the petition number 1 against the respondent before a Mahila police. P7 is a certified copy of an FIR registered on the complaint given by the petition number 1. P8 is a certified copy of a wound certificate. P9 and 10 are certified copy of a wound certificate of petition number 1 issued by. So the P11 is certified copy of a charge sheet. P12 is a certified copy of the deposition of a petition number 1 and PD number. P13 is a certified copy of a sale deed dated 1710 regarding purchase of the property by Mahavir Vartaman Jain and his wife Akshata Jain. Now, the registered sale is standing with the joint name of the couple. The P15 is a record of rights of serial number so and so standing jointly in the name of Mahavir and Akshata Jain. The respondent thereafter the objection. The respondent has filed his affidavit in lieu of an examination chief as Article 1 and deposed evidence that petition number 1 is not his legally wedded wife and he has not married the petition number 1 at so and so and so. The petition number 2 is not his daughter but born to the petitioner from the Mahavir Jain of Hassan. The petition number 1 married with one Mahavir Jain of Hassan and also got divorced from him. The petition number 1 doing private work and getting 15,000 per month, he is not having any bad habits, but the petition number 1 filed case in CC number 7 against him and his relatives before the Hubballi court and they have acquitted in the same case. He has not given any copy to the petition number 1 by demanding dowry. He was working as a security in Kudremukha Iron Ore Company from 15 to 18 and getting 8,000 per month and now he is not having any job. In the year 2019, he undergoes for surgery of his stomach in Manipal Hospital and has taken treatment for 15 days as inpatient and spent rupees 1,10,000. In the year 17, his father undergone for heart surgery and stunt has been inserted in his father's in Kasturba Hospital, Mangalore, and taken treatment for 15 days and spent rupees 3 lakhs for the same. Further, his brother, father, mother, and children of his brother tested with the COVID positive and has taken treatment in the government hospital, Mujibri. The petitioner spent more than 5,000. Further, his brother tested with the COVID positive and taken treatment in Mangalore hospital for 40 days and spent rupees 35 lakhs for the treatment, but the state amount is paid by the government in gas for the expenses of medicines. 5 lakhs from the Mumbai. Now he is doing fully work and getting rupees 300 per month and safe work is for 4 months when there is a season for a supari, office, coffee, pepper. Further to meet the above state, all the medical expenses he has mortgaged his property with one so and so for 2 lakhs and further he has taken loan of rupees 1,05,000 from so and so in the year 2019 and has also taken loan from amounting to rupees 1 lakh. Further he has purchased site bearing number so and so 4 cents in the Kallagutta village for 24,000 and he has half share in the said property due to the oversight in the said sale. It is wrongly mentioned as a wife by and by mortgaging the said property as obtained hand loan. His family is dependent on his brother's earning. The petition number 1 interested in not putting the documents to show the name of the organizations in which he is working. He has filed objection to the main petition and prays to dismiss the petition. In support of so and so, he has produced the lab reports of the respondent. He is assessed.
Yes. Just because the say document is in their joint name, that cannot be a ground for the court to say that she's the-
Not only that, my lord, even my lord, so far as the marital relationship, in the cross examination, he specifically says, although he says that he has not married, he says in the cross examination that we live together.
That is sufficient.
Please, my lord, if
Under 125, that's
my
sufficient.
lord, if for a considerable period of time, if the
Let's see
partners-
125 CRPC.
my lord, consistently, my lord, reports have held that if partners live for a considerable period of time together, my lord, the presumption of a valid marriage arises. Marriage presumption of a valid marriage.
Any person having sufficient seconds to
Contrary will have to
maintain.
prove by the, my lord, even in the cross examination of the CC, my lord, in 498
No, first of all, she has to be his wife.
please, my lord, they have not disputed, even in the cross
Who has not disputed? Is disputing.
my lord, in the cross examination, for a moment. Firstly, so far as the cross examination of this petition, they say, we live together, living together, they can contain in cross examination. So far as in CC, my lord, in 498 matter, in their own cross examination, their own suggestion, that we stay together there for 2 years, in Hubli for 3 years, their own suggestion, that for a long
You have filed the petition as a wife. You are not saying that we are living together. You said you are a wife, but then you have to prove there are a relationship of the wife and husband, that there is a marriage. It is not your case.
My observation, it is our strong submission that we were married.
Where is
But
evidence?
in the event,
No, there cannot be any event. There are two different aspects. One is you saying, coming to the court and saying that though we have not married, we have been living together as man and women. So, still, in view of the law, please listen to the court. I am entitled for maintenance is one scenario. Second is you claiming that I am a legally wedded wife of so and so. So and so denies it. Then there should be some evidence before the court to show that there is a marriage. It is not about living together. It is about a marriage. Where is the evidence? Your client says that in the evidence that there is none. She has not placed anything on record. She was divorced. Whether that divorce has happened, When the divorce has happened, nothing has been stated. And even the girl is born out of the first marriage.
Please, no, that's our government. We have fairly made a so far as that matter is concerned. Lord, the registered sale is allowed. My husband and myself have purchased in the capacity of husband and wife. Lord. There is a registered sale, Lord, and that remains intact. Lord, his objection may kindly look at, Lord. He himself says that after obtaining divorce from the first husband, so far as the divorce from the first husband is concerned, it is his objection, Lord. Can we come to page number 0? They have not disputed that I have obtained a divorce from the first husband. There is not a matter in question at all.
What is matter in question is when is your marriage? How did it happen?
Lord.
Unless and until it is a marriage, solemnized as per the custom.
Please.
It is not a marriage.
So happened. Submission, whether it's CC Lord, here Lord, submission is that since childhood, the partners before the court, Lord, there is a
Please understand, that is what you know, but court can only know from the papers, from the evidence.
I was considered to seek divorce within no time. Hardly
We can't help it, but we can't help it. You have to place a positive evidence. First of all, the relationship of the wife and husband has to be established.
Joint photo of the petition number 1 and 2, my Lord.
Please come to the last paragraph. Therefore, the version of the petitioner number 1 that no photos were taken at the time of her marriage with respondent and marriage card is not printed. There are no believable documents produced before the court by petitioner number 1. The documents produced in this case marked by her does not prove her marital relationship with respondent. Therefore, she failed to prove regarding the marital relationship with respondent.
Their own cross-examination, their own suggestions in the cross-examination, which evidently there that he admits the relationship, he admits that he stayed for a long time as
Staying together is not what is required under 125 CRP. And your version that you are the wife.
Directed me to get any judgment in the context.
No, I'm telling you that there are two different aspects. Saying that we have been living together and I'm entitled for maintenance under 125 is a different factor. So you claim yourself as the wife, then you have to prove it. So that judgments will not come to your rescue.
In the short span, my Lord, since I was married, my Lord, he constrained me to seek a divorce in no time, my Lord, since we had an affair, since the childhood, since early days of life, my Lord, on his instance, my Lord, I took a divorce in no time and started living with him, my Lord, since it was the second marriage, my Lord, it was arranged in Harry, my Lord, they don't stoutly admit, they admit it, my Lord.
So if it is a marriage, you will have an Aadhaar card at least.
Please.
If it is, let's forget about the photos. Basic now, everybody's identity is an Aadhaar card.
Please,
where is the Aadhaar card?
The records, the exhibits,
please look at it. Please look at it.
No, the exhibit P2, P2 indicates the Aadhaar card is petition number 1 and 2.
Now what it says? Petitions number 1 and 2.
No, petition number wife.
1 and 2 is not wife and not wife. It is daughter and mother's ID card.
The petitioner's identity of the petitioner is wife of
her husband name and this person's name is also one and the same.
Please,
So, please come. The present petition is filed by the 5. Agreed with the orders passed in criminal miscellaneous number 13 of 2017, date 20th January 2023. The petitioner herein has filed a petition under section 125 CRPC against the respondent's civil maintenance. It is a case of the wife that the marriage was solemnized as per the Hindu Jain religion, Rivas, caste, rites and customs on 17/7/2006 at Padmavati Temple, Kudure Mukha. That it was a marriage with the consent of both the families. And during the marriage, certain articles and cash were certain articles, gold and other articles were given. It is a case that she was earlier married to one Mahavir Jain, and identically this petitioner's name is also Mahavir. Mahavir Jain of Hassan on 25/6/2015, and thereafter, as she was not thereafter, as the respondent is Levin was in love with her since long time, could not tolerate the said development, and rushed to her matrimonial home and intimidated all his previous affairs with her. in- Intimated all his previous affairs with the petitioner to her matrimonial family members, followed by threat of severe consequences in the event of relationship loss, and got the wedlock concluded, which subsequently ended up with divorce. Thereafter, this marriage has taken place. The child, that is petition number 2, is born out of the wedlock with the previous husband. The husband proclaimed the child to be of his own, only with the sole intention of marrying her. That it is a case that the husband had got a, had got addicted to bad vices and started coming home late night by consuming liquor and assaulted her and also abused her, and also snatched an amount of include 3,50,000 amount from her, which she got by divorcing her first husband as one-time settlement, and he has used the said amount for purchase of a site in joint name, which was bona fidely agreed by her. It is a case of the wife that the family members of the husband assaulted her and her mother, and also threatened them to do away with their life. As such, the mother and the petitioner, without having any base, actually rushed back to Davangere and got the medical aid. When she came back to Hubli, she found that all the articles and other belongings were taken away, and immediately she filed a complaint. And thereafter, after police conducting an investigation, filed a charge sheet, that is 727 of 2015, which is pending on the file of the second JMFC Court, Hubli. Then she has separated from her husband, as she has no ways of maintaining herself. She has filed this present application seeking maintenance. Next para. The husband had filed his objections and denied the relationship. According to him, the petitioner is not his wife. And she has stated about the relationship with the first husband, and that the girl has born in the wedlock with the first husband, and she is not his daughter. The court, by order impugned, had dismissed the case of the wife, as she has failed to prove the relationship of they are legally wedded wife and husband. The court observes that even as per the evidence of the wife, that the no photos were taken at the time of her marriage, and the marriage card is not printed, and no other reliable evidence is placed on record, and the documents produced by her does not prove the marital relationship with the respondent, as she failed to prove the marital relationship The court had dismissed the petition. Next para. Then counsel appearing for the petitioner submits that the property, one document, that's a property stands in the name of both the petitioner and the respondent, which clearly shows that she is the legally wedded wife of the respondent. And he submits that the because of the relationship the petitioner, the respondent has, she had divorced her first husband, and even he has taken away the money which was given by the first husband. It is submitted that they have been, even he has accepted that they have been living together, they have lived, and there has been a relationship of a man and woman. As such, the wife is entitled, as such, the petitioner is entitled for maintenance, and all these aspects were not considered by the court. Next paragraph. Though notice is served on the respondent, no wakalat is filed on his behalf. Next paragraph. Having heard the counsel for the petitioner, produce the material on record. It is the case of the petitioner that she is the legally wedded wife of the husband. That is, there is a legally wedded wife of the respondent, comma, respondent has failed to maintain her, and she has been staying away from the husband with a reasonable cause, and there is a duty cast upon him to maintain her. To go into the other aspects, the first and foremost aspect is that she is a legally wedded wife of the husband, of the respondent. Respondent denies the same. The wife had filed several documents, had filed the documents that they are the wife and husband. The documents that were filed do not disclose that there is a marriage between the parties. For claiming maintenance, that she being the wife, it is her case that the husband had to maintain her. And the first aspect itself could not be proved by the petitioner that she is a legally wedded wife of the respondent. The court had rightly held that she is not entitled for maintenance. In this case, the name of this respondent in this case, and the name of the first husband is also one and the same, even in those circumstances also. From the Aadhaar card, wife of Mahavir, as it is mentioned, that also as cannot come to the rescue of the petitioner. In the considered opinion of this court, the court had rightly considered all these aspects and dismissed the petition seeking maintenance. This court finds no reasons to interfere and accordingly dismissed. Next paragraph.
Are there? Alam Qazi?
For the petitioner.
No representation for the respondent on the last occasion also. From where to where you are seeking?
Bilingual to Dharwad.
Which year is the MC? Which year is the MC? 24.
2024.
What is the distance between both the places?
50 kilometers.
Any other petition pending at your place?
Yes, my lord. In Dharwad, criminal misdemeanor is filed by the...
Yes, please come. The present petition is filed.
Respondent is also working in the Haryana. It is convenient for him.
The petition is filed. Seeking transfer of MC number 44 of 2024, pending on the file of the Senior Civil Judge, Well Homegar to Principal Judge, Family Court, Dharwad. The facts of the case are the parties, the marriage between the parties was solemnized on 2/2/2022 at Dharwad. In view of the differences between the parties, she had to stay at her parental house at Dharwad. Thereafter, the husband had filed MC number 44 of 2024 on the file of the Senior Civil Judge, Valhomgal, under seeking divorce. the wife had filed criminal miscellaneous number 154 of 2024 on the file of the Principal Judge Family Court, Dharwad, seeking maintenance. The distance, it is the case of the wife that the distance between both the places is about 50 kilometers and it's difficult for her to travel. And as she had, also there is threat to her life from the respondents. It is submitted that the husband is working in Dharwad.
Yes. Haryal.
Huh?
It is near to Haryal.
He is working in Haryal, which is near to Dharwad. And even if the matter is transferred to Dharwad, it would be in the interest of the husband, it would be convenient for the husband also. When this matter came upon 7/11/2024, as there was no representation on behalf of the respondent, this court heard the counsel for the petitioner in part and directed the matter to be listed today under the caption Part 3rd. Today also, there is no representation on behalf of the respondent, and this court is inclined to pass orders on the merits of it. Expera. Having heard the counsels on either side, counsel for the petitioner, there is the material on the court. The wife is seeking transfer of the case from so and so to so and so. The distance is 50 kilometers, and she has already filed a maintenance case which is pending on the file of the family court Dharwad. And considering the fact that a case is pending at Dharwad and the distance is 50 kilometers, and the inconvenience being caused to the wife, this court deems it appropriate to pass the following order. So and so is withdrawn from so and so and transferred to so and so. Accordingly, appeal petition is allowed. Next.
Admission petition number 27. Tell us the Deepak Kulkarni.
The respondent number 1 to 5 herein filed a suit for declaration and injunction to declare that the sale deed executed by their brother and defendant number 3 to 5 is null and void and not binding upon theirs. Plaintiffs are the my lord's wife and children of the defendant number. He has executed a sale deed. They are now seeking a declaration. It is nothing but a cancellation of an lord's sale deed executed by defendant number 2 to 4.
When was the sale deed executed?
In the 2010, 14/10/2011. So my application is super as my lord's court fee, but in view of my lord's, my friend would consider that could be considered. In view of full bench judgment of this court, that has to be tried at the time of and that is the law subsequently has been said. Full bench has taken away, it cannot be treated as a preliminary issue or order 7 to 11 application.
It will be decided as one of the issues, whether the court fees paid is sufficient or not.
That is true, my lordship. If my lordship, I am not saying that is the law subsequently I can make. As per the plaint allegations at paragraph number 13, they not sale deed is 6,30,000. As per the plaint allegations, property.
No, they are not. They did say that it is not binding on them.
So if it is not binding, if partition is there, I could have said that they are right.
What is the suit for? Declaration.
For declaration and injunction, not any other place. Only that is declared. To declare that sale deed is not binding upon their sale. But if they are short, my lords, partition, then I could have.
No, they are not parties to the document.
Well, if they are not parties, but it is nothing.
No, if they are not parties to the document, they need not seek cancellation.
This court has taken a view.
There is a judgment of Justice Rabindran, I think, on it.
There also the Supreme Court says that when that entire sale deed is going to be declared as a null and void, either it is indirectly.
No, I think that's a distinction that's made about a parties to a deed. A party is not to the deed.
If party is not to a deed, it amounts to for cancellation. If a second prayer could be either a first prayer or second prayer partition.
No. But the court has consciously made the distinction between a party to that document, who is a party not to the document.
Partition suit and other reliefs are
It is not about a partition suit, it is about the document. Because they are not parties to it. That applies anywhere, whether it's a partition. or otherwise? What is the judgment that's? That's a Supreme Court judgment. That's a Supreme Court judgment. This is 2014, that is much later to this. But this is how can, what is the ratio later on in this judgment? No, first of all, to consider this judgment as a precedent, where is the discussion in this? Yes, please come. No, collect the court decide, you will get an opportunity. Unnecessarily, why should this court give a finding?
No, I'm not saying. Subsequently,
The court has already decided in respect of court fee minor. I'm also relying on judgment of court. It's similar tax law. That is a suit for declaration and injunction. The Honorable Court has
Suhru Singh's case. That is what is the judgment. Huh? Huh? Suhru Singh's case. Anyway, we are not going into that issue.
I'm only requesting that it could be tried as a complaint.
It could be?
At the time of final activity.
well, already decided, my lord, in respect of court fee. The trial court has already decided. Again,
Let's see, let us see what is the plaintiffs being non-executants have currently valued the suit. On the conditions that the plaintiff need not pay ad valorem fee on the market value of property as on the date of filing of the suit or on the sale consideration amount. Yes, why do you want it to go back?
Lord, sir, I'll take notes to page number 30, green.
No, that is a simple issue which you have stated. Court has decided. So there is nothing wrong with it. Why should this court interfere? Unnecessarily, why it should go back again? That's a law. That's a law. Please read this judgment. Give him a copy of it. Yes. Pass over. Same, similar, identical circumstances.
Yesterday's matter, they made a submission that FDP is disposed. Yesterday they said they made a submission. The CRP will not survive for consideration as the FDP is closed.
Yes, sir.
My lord, that FDP order is challenged before appellate court and that has been set aside.
Set aside.
Please note.
He set aside.
Yes. On my lord, on 1st April 24.
So now the final degree proceedings are pending.
Yes.
Let them appropriate that. Let them appropriate that activity. Any of these is not demanded now. But the present petition is not appealing in that activity. The other respondents who have dependency in the OS.
No. When he is a party to the appeal, and now the order is against him, how can he work out in FDP now?
In this section, you can challenge the set aside order RA 3/12. This is RA 4/23. He is not the applicant, so this is RA. He is the respondent number.
That's what, because you were set ex parte in that.
Please.
You want to contest that matter. That's what is the scope of this.
Within 3 months it can be disposed of. I'll go up with
And accordingly, basing on that, the final degree proceedings will be
conclusive.
That is the extent of what has not acted the delay law. He says that notice has been served upon him when he was straight from the Dharwad. Notice was priorly served upon him and there is a delay in concurrence in execution.
Oh, but that's what this 2020 happily he kept quiet. so that things will go on without no stays granted.
No, that was done in RA. That was the interim order. Therefore, the interim order was not closed.
How much till when the interim order was there in RA?
No, that is RA is of 21. There was an interim order. And in this response number 5 expired in 21. Application was made. That came
What
to
is the suit for?
A suit for the partition and separate possession.
You are the
I am the defendant.
member of the joint family?
Yes. But kindly tell you kindly tell me you page 20. You page 20. Kindly tell me you page 27.
But anyhow, it should be your, it's between the members of the joint family. You are also a member of the joint family, or you are a purchaser?
No, member of family.
Let it be decided.
3 months
And we'll also fix a time frame to decide that case.
3 months.
One more suggestion. The present application is an own brother of these present applied by the core of the they are polluted each other. They are residing in the same house. In this cross-examination at civil litigation, he himself has admitted because they are residing in the same house. They
But he has not.
and now they come up to civil litigation. That was there was a dilemma, and that has not been properly explained before the lower court. As such, they have this.
No, what happens is, that the whatever the decree that is passed long back, you are not able to enjoy the fruits of the decree. Now the final degree proceedings are set aside. So instead of all this, that there be an adjudication. We'll say within 3 months, no adjournment shall be granted, because everything is on record. Whatever he wants to submit, that only will have to be decided now in the first appeal. And that appeal is yours. There is nothing much from his side to do it now.
Yes.
One more suggestion. Anyhow, right now only RA has been this RA4 what because they have ordered that the FDP should be they have demanded the right to FDP. Let them work out their share and make FDP.
First of all, you are not. No, you are agreeing with what is the decree of the trial court.
Please, I am agreeing with the decree of the trial court. Let them work out their share in FDP.
No, it is like this. No, what he says.
My appeal was allowed. When I seen the shares, that was allowed ex parte decree. That was
that
allowed. I am thinking.
No. But the suit is decreed.
Suit is decreed.
You preferred an appeal. Appeal is allowed. Then he has filed an
He filed a misdemeanor petition. That is allowed. The appeal is restored. In the restoration of that appeal, the notices are served. I will case ex parte.
And the court decided it.
No, not on merits. This is not before. Therefore, I am seeking one apology. 3 months time will be granted. I will argue the matter next day itself. I will not seek more adjournment. Only take an appeal. Because shares are well modified. It has been enhanced.
Not 3 months,
1 month. 3 months itself is a time. It's a very short time.
In page 27.
It has to be not happening. No, it's happening. Why? I think then why don't you call them? Why don't you call the computer people? The present revision is 5. Agreed with the order dated 9/8/2017. What is the order? Then what were you doing till 2020?
No, 9/7/2020.
Where is that order?
Page 51.
In page
51. In page 51.
This is the impugned order.
Yes.
Agreed with the order dated 9/July/2020 in cell miscellaneous number 20 of 2018 dated 9th July 2020, the appellant in RA number 3 of 2012 is before this court. The petitioner herein, the respondent herein has filed OS number 23 of 2018, seeking partition and separate possession of the one-third share in the suit properties. The suit came to be decreed on 28/9/2011. Then the defendant number 2 to 4, 1 to 4, defendants 1 to 4 have filed RA 3 of 2012, and the said appeal came to be allowed and modify the shares of the plaintiff
And defendants.
plaintiff What is this? No. The said appeal came to be allowed and modify the shares of the plaintiff.
Yes.
Then plaintiff had filed FDP number 2. How can it be disposed of?
In page 27.
Not in page. I am looking from page 53. We have 53 of the order.
Please.
From the top 3 lines. That much.
That because of that FDP which was pending, in view of the pending of this appeal, there was an interim order. The court said, when after the disposal of RA, you seek for filing of FDP. That FDP.
Pending disposal of the RA, when the FDP is filed, the same was disposed of, giving liberty to the plaintiffs to file the same after the disposal of the appeal. Thereafter, the plaintiff had filed an the plaintiff in the suit, the RA came to be
restored. On the miscellaneous score of 2000.
The RA came to be restored on the application filed by the plaintiff, that is miscellaneous number 4 of 2013. In that, a notice was served on the defendants, and thereafter, as there was no appearance on behalf of the defendants, the appeal was dismissed for non-prosecution. And after the appeal being dismissed, the plaintiff had filed FDP number 29 of 2007.
Please.
Thereafter, miscellaneous 20 of 2018 is filed by the defendants. Defendant number?
Defendant number 1.
Defendant number 1, stating that he was not aware of the restoration of RA number 3 of 2012. The notice served to them, the notice issued to them was not duly served. It is their case that during the month of October 2017 to April 2018, they have taken active participation in the Khalsa Banduri agitation. And they went to Bangalore and Delhi to intensify the protest. As such, they were not aware of the restoration of the appeal, and they could not instruct their advocate. And there is no reason for the defendants not to appear before the court. They came to know about the said order when the Commission's notice in FDP number 29 of 2017 was served upon him. Thereafter, they filed for the certified copy and came up before the court. In the process, a delay of 322 days occurred in filing the petition. Hence, they filed an application to condone the delay and to set aside the ex parte or the default order. The plaintiff respondents have objected for the said application. Court observes that the court has given sufficient opportunity to the parties to appear and to contest the appeal, but in spite of granting sufficient opportunities, they have not appeared before the court. Hence, the court had dismissed the appeal for non-prosecution. If the RA is restored to its original file, the respondents will be put to mental and economical loss, and on the other hand, if the petition filed where the petition is dismissed, no harm or loss will be caused to the petitioner. The trial court had dismissed the application, that is miscellaneous 20 of 2018, filed by the petitioner, who is the defendant, observing that the ex parte order was on 29/9/2018. Perusal of the order sheet reveals that the defendants number 2, 3, and 4 are served. They have not engaged any advocate, hence they were placed ex parte. Then, after restoration, court notice is issued on 36/2017, has been received by the defendant number 1 on 8/7/2017. Subsequently, ARIA 3 of 2012 was listed on 27/2017, 27/7/2017, 31/7/2017, 3/8/2017, 5/8/2017, and 9/8/2017. On all these days, he has remained absent. The court also observes that there are 4 appellants, and appellant number 1 alone has filed seeking for restoration of the case. It is also forthcoming from the records that appellant numbers 2, within brackets A, B, C, were also served. The reasons for their non-appearance has not been explained, nor they have stated anything in this petition. The court submits that the reasons that are stated for condoning the delay, for not appearing before the court, are all imaginary, and they failed to put forth the case with valid reasons for condonation of the delay, and accordingly, the petition filed, that is miscellaneous 20 of 2018, is dismissed. Aggrieved thereby, the present revision is filed. There are no interim orders in this case. There is no stay granted by this court. And the matter came up on the last occasion when counsel for the respondent submits that already respondent plaintiff that the already final degree proceedings are final degree proceedings are concluded. Today, on that, to get instructions, the matter was adjourned. Today, the counsel appearing for the petitioner defendant submits that when the matter was carried to the Honorable Apex Court, the final degree proceedings were set aside by order dated
1/4/2023. 1/4/2024.
by order date. Not the Supreme. Where is the Supreme Court order? Just now you said so. In the morning. You said like the matter was carried to Supreme Court, something you said.
No. That FDP order which was not yesterday that due, that was challenged in Malone RA.
Yes.
They said the FDP is closed. Therefore, this year
against FDP proceedings, RA number 4 of 2023 is filed, and the same came to be by order dated 1st April 2024.
last
The 24. The first edition Principal Judge Family Court, Gadar, had set aside the order dated 8/12/2022, passed in FDP number 29 of 2017, and the matter is remanded back to the trial court to reconsider the matter. Next part. The counsel appearing for the petitioner defendant submits the court has failed to consider the reasons that are stated for condemnation of delay, and court failed to understand the substantial rights involved in the case, and not to have given a fair opportunity to the party, to the defendants, to contest the case. Now, by virtue of the order passed by the first appellate court, the shades were increased. Now, if the same is dismissed for non-prosecution, it would cause a lot of hardship to the petitioner defendants. He submits that if an opportunity is given and as without seeking further adjournments, they'll proceed with the matter and appropriate orders can be passed by the court. Next part, let counsel appearing for the respondent plaintiffs, two plaintiffs, two in number. One, the respondent plaintiff submits that without any valid reasons, or only with the intention to protract the litigation, they have not appeared before the court. And the court had rightly observed on what all occasions they were not present, and court had given enough opportunity to the defendants. When they failed to explain the proper reasons for the delay, the court had no other option but to dismiss the application. He submits that when an application is filed under Section 5 of the Limitation Act, they have to come before, they have to explain to the court the reason for the said delay. Next one. In the same manner, he submits that the court had rightly dismissed the petition. He submits that if at all they are agreed, they can agitate the same before the court, where the final degree proceedings are pending. Next one. Having heard the learned counsels on either side, produce the material of record. The suit that is filed is for partition and separate possession. The court had, in fact, the suit is decreed, and the appellate court had passed an order whereby the shares of the defendants were increased. And later the same was restored, and then it was dismissed for default. This court has perused the reasons that are stated by the court. No doubt there are lapses on the part of the petitioner, defendant in appearing and pursuing the matter. But considering the fact that this is a suit for partition and looking at the substantial interest of both the parties, this court deems it appropriate to grant an opportunity to the defendant to contest the matter. Accordingly, the court is passing the following order. The order passed in the same is 20 of 2018, dated
9/7/20.
Dated
51.
where do you get the date? Date is
51. 9/7/20.
1 minute. Dated 9th July 2020 is set aside. Consequently, is set aside on the condition that the petitioner shall pay an amount of rupees 20,000 to the petitioner plaintiff, a respondent plaintiff, within a period of 2 weeks from the date of receipt of the copy of the order. Number 2, the trial court shall decide the matter within a period of 3 months from the date of receipt of the copy of the order. No unnecessary adjournments shall be granted, and granted accordingly disposed of.
They are not given fees to them, they are very such a poor persons. I have been doing it for free of cost, and they are discussing between brothers, giving cost to another brother.
No, but then if you're so poor, don't claim to keep quiet. You have to, there should be something.
Yes, for something, some leniency, because.
10,000.
Please,
Yes,
please.
sir.
Seal number 29, what's the side check? Yes, sir.
We were directed to file affidavit. I served copy on the list and I'm telling it today.
Then counsel for the petitioner representative, today they are filing the statement of assets and liabilities and they have served a copy on the counsel for this morning. This morning shall go through the same and make submissions on
Week of the next matter.
Huh?
Week of the next matter, my time will be
26th November. Yes, next. Interim order is there. In interim order, if the interim order is there, extend. Yes, next.
Seal number 30.
30 adjourned.
Seal number 31. Precious. Another mistake.
Yes.
This petition and the petitioner, who is the defendant number 7 in the trial court melodies. The plaintiff says that plaintiff says that they have purchased the suit property.
What is the suit for?
Suit for declaration and injunction melodies.
You are the defendant in the suit.
Yes, melodies.
What is the IA?
IA for rejection of claim melodies.
On the ground?
On the ground, there is no cause of action arising.
There is no
cause of action.
Cause of action for them. So please come to the plaintiff. Where is the plain page number?
53.
53.
53.
Yes, sir.
59 months.
59 months cause of action.
The cause of action to file the present suit arose in the first week of October 2017 when some of the strangers visited the suit property being intending purchasers and shown RR carrying the name of defendant number 1. Declaration decree declaring the plaintiff and defendant 2 to 6 are the owners of the suit property by virtue of the sale deed executed on 16/11/1953. Permanent injunction. Then please come to your IA. Where is the affidavit? Where is it?
Page number 42.
Page number?
42.
40.
Affidavit number 43. And the detail number 7. The tenant is suit not use the purchase the property.
Please come to the order now. Where is the order?
Page number 35.
35.
Order 9. Page number 38.
Yes, what do you say?
Yes, my submission is not perhaps plaintiff says that they have purchased suit property in the year 1953 minutes. At that time, my lords, the Bombay Prevention of Fragmentation and Consolidation Act was into the force.
So all these things, how the court can decide now? In a petition under Order 7 to 11. But all the contentions that you are raising, that can only be decided during the course of trial. And as per the averments of the plaintiff, he has made out a cause of action to file the suit.
In 2016, they have filed the 7 application before the.
That who will tell? That they have not told, they have not said so in their plaint. That you are saying. And your written statement cannot be looked into.
In the plaint, they have specifically mentioned that matters. Their ME number 184 cancelled by the Tahsildar Belgaum matters. Deputy Commissioner Belgaum matters. Therefore, they have not. They have to approach before the land tribunal matters. They are approaching the Honorable Civil Court ethical matters. So, since
where do you get that?
19,
where do you get that? But unfortunately, the application that is filed and the reasons that are stated by you on that ground, the plaint itself is not in accordance with law and is hit by the provisions of the CPC. The facts narrated in the plaint are insufficient and do not harmonize with true material facts. It is nothing but an abuse of process of court and bars the jurisdiction of the court. And accordingly, it has to be rejected. That's what you have stated, sir. Let's see the plaint again.
They have filed 7 application by.
Let us see. Please read to show that particular paragraph.
Yes. Page number 7 minutes. Even though the ME number 184 was cancelled, being hit by the Bombay Prohibition of Fragmentation and Consolidation of Holdings Act 1947, the possession of the suit property continued with the purchaser and his family members. Even after that, the purchaser also possession and enjoyment of the suit property is the plaintiffs and the other family members. Till today, the said possession and enjoyment of the suit property has remained continuously uninterrupted by the anybody, including defendant number 1 and his family members.
Please come. Agreed with the orders passed tonight, number 7, in OS number 120 of 2017, dated 27/10/2021. The defendant is before this court. The respondent herein, who is the plaintiff, had filed the suit seeking the relief of where is that plaintiff? Page number
54. Page number 54.
Seeking the relief of declaration declaring that the plaintiff and defendants number 2 to 6 are the owners of the suit property by virtue of the sale deed executed on 16/11/1953, and also sought for an injunction restraining the defendant from disturbing the peaceful possession and enjoyment of the suit property by the plaintiff and defendant number 2 to 6. It is a case cause of action to file the present suit arose in the first week of October 2007, when some of the strangers visited the site suit property, being intending purchases, and shown the R/R carrying the name of the defendant number 1. Thereafter, they have filed a present IA. The suit is filed, and they filed the defendants have filed the present IA, seeking rejection of the plaint. It is the case of the defendant that the suit is barred by the law of limitation, as the present suit is filed on 4/12/2017. Almost 6.5 decades have been lapsed in pursuing the suit based on a registered sale deed in the year 1953, and it is impermissible under law. And the plaintiffs are guilty for the gross abuse of process of law by creating they've unrepentantly resorted to by creation of an illusion and title or the suit property, which does not belong to them. Even the cause of action alleged by the plaintiff in para number 11 of the plaint is an illusion and created to serve their purpose. And the suit cannot survive because the right of the sue accrues only when the cause of action arises for the first time against the defendants and then the suit is liable to be dismissed. The trial court, by order impugned, had dismissed the IA and while dismissing the IA, the court observes that under Order 7, Rule 11D, the plaint can be rejected where the suit appears from the statement in the plaint to be barred by any law. It is evident from the provisions that there must be a statement in the plaint itself which should appear to the court that the suit is barred by law. Upon perusal of the entire plaint amendments, the court do not find any such statement from which the suit appears to be barred by law. Court observes that the defendant number 7 has not quoted any exact legal provision, such as section or rules of CPC, or the rules laid down under the provisions of the Karnataka Land Reforms Act. The court felt that the application is filed only to drag on the proceedings, and it is a fit case to impose costs on the defendant number 7 for filing the vexatious application. However, taking a lenient view, in looking at the suffering of the people because of COVID-19, without cause, the application is dismissed. Next para. Land counsel appearing for the defendant number 6, the petitioner defendant number 6 submits that when the MA filed by them is dismissed, they have to carry it in further appeal. They have to go, what they have to do, what is the remedy according to you? They cannot file a suit.
Yes, ma'am.
A civil suit
According to
is
the
not maintainable.
Karnataka Land Reformation Act.
Under the Land Reforms Act, they have to approach as such. The suit is not maintainable. This aspect is not considered by the court. Further, the sale deed that they are relying on is of the year 1953, and the suit is barred by limitation. And the court has not considered all these issues. Next para. The counsel appearing for the respondent plaintiff submits to the court had considered all these issues, and particularly the fact that the issue of limitation and other things are open. The other things cannot be, the issue of limitation is a mixed question of fact and law that cannot be decided at the threshold. And court had rightly observed that petitioner failed to make out a case where the plaint has to be rejected, and he submits that the order passed by the court is in accordance with law and no interference is called for. Next para. Having heard the counsels on either side, there is a material on record. The suit is filed seeking a declaration that he is the owner of the property and a consequential injunction against the defendants from interfering with his possession. It is a case of the plaintiff that the property was purchased way back in the year 1953. And according to them, they have been in possession of the property ever since. And first time when they came, when the prospective purchasers came to the site, came to the place and informed that the revenue entries are in favor of defendant number 1. For the first time, they came to know about this. As such, they sought for a declaration. The contention with regard to whether the suit is maintainable under the provisions or in view of the bar under the provisions of the Land Reforms Act and other things have to be decided cannot be decided basing on the plain governments for that. The details with regard to dismissal of the application, how it is dismissed, what has happened, for all the relevant aspects, it can be ascertained from the written statement or the objections that are filed by the defendants, which cannot be looked into while considering an application filed under Order 7 Rule 11D. And the cause of action, according to them, there is no cause of action. But the abide perusal of the plain shows that plaintiffs are the cause of action. And in those circumstances, this court is of the view that the court had rightly dismissed the application filed under Order 7 Rule 11D, and this court finds no reasons to interfere. Accordingly dismissed. Any signatures? Give it to the court office. Huh? Yes, yes, yes.
Well, it is a registered
Might be. Thought vitiates everything.
Yes, she is without getting age about 80 years old also. She is without getting age about 80 years old also.
Please come. Agreed with the orders passed in I number 7 in OS number 240 of 2019, dated 17 September 2022. The defendant is before this court. The respondent herein has filed a suit.
Number 6 will also.
I number 6. But it appears to be I number 7.
No, 6. Number 6 will also.
order is at page number 47.
Oh, not 36.
That is final order is at 47, page number 47. It is I number 6 at the bottom.
If you look at the page number 36, top.
It is wrongly mentioned. No, it is I under order 7 to 11.
Oh, IA order.
I under
Yes.
order 7 to 11.
IA number 6 is filed under order 7 to 11, seeking rejection of the plaintiff. The respondent herein has filed a suit for declaration that the gift deed executed by her on
4/8/2016.
4/8/2016. Let's look at the plaint.
Plaint is at page number, prayer is at page number 16. Para number 18, prayer column.
That to declare that the gift deed created by husband of defendant number 1 from the plaintiff on 4/8/2016 in respect of the suit property is null and void, and also sought for an injunction against the defendants not to obstruct peaceful possession and enjoyment of the suit property. It is a case that the plaintiff is an old lady and she has having 2 sons. One son died on 4/11/2019. She purchased the land in the year 1983 by selling the land given to her father and brother. The suit property is a self-equate property of the plaintiff. The husband of the defendant number 1 giving assurance that for sanction of the old age pension amount brought her before the sub-registrar, and God created the gift deed in his favor. Due to undue advantage of the illiteracy and old age, they got the gift deed. It is a case that she is in possession of the property. When the defendants are trying to interfere and evict her, and thereafter, when she obtained the certified copy of the revenue records and gift deed on 25/9/2019, she came to know about the alleged gift deed and came with the present suit. In that, the defendant herein, who is the petitioner herein, who is the defendant therein, had filed an IA under order 7 to 11, seeking rejection of the plaintiff. The grounds urged before the court are that on the date of execution of the gift deed, the possession of the suit land has been handed over and the names are mutated. That the suit is barred by limitation, as a gift deed is executed on 4/8/2016. The suit came to be filed on 25/11/2019, and accordingly, they requested the court to check the plaintiff. The same is dismissed by the court by order impugned. While dismissing the same, the court had considered the judgment, this court and the Honorable Apex Court, and comes to the conclusion that law of limitation is a mixed question of law and fact, and it has to be decided at the time of trial, and at this stage, it cannot be considered and accordingly dismissed. As per learned counsel appearing for the petitioner, defendant submits that from the plain evidence, it can be, it can be, it can be demonstrated that the suit is beyond the suit is part of a limitation, and not necessarily that it's a mixed question of fact and law. And the court had, without any basis, had rejected the application. Next para. Learned counsel appearing for the respondent plaintiff submits that the court had rightly dismissed the application. He further submits that it is a case of the plaintiff that a fraud is played on the plaintiff and got the document executed. He submits that fraud vitiates everything, and the trial court had also further rightly held that a limitation is a mixed question of fact and law, and dismissed the petition. He submits that there are no grounds to interfere with the well-considered order passed by the court. Next para. Having heard the counsels on either side, there is a material on record. A gift deed that is executed by the plaintiff on which day?
4/8/2016.
4/8/2016, and she wants and she has filed a present suit seeking cancellation of the same on 25/9/2019. The clear evidence of the plain that she was taken to the sub-registrar's office that she will be getting the pension, and this document came to be executed. She is alleging fraud, and according to her, fraudulently, such a gift deed came to be got to be executed, came into existence. Apart from the fact that the issue of limitation is a mixed question of fact and law. Apart from that, then this is a case where the fraud is alleged by the plaintiff. In view of the above discussion, this court is of the considered opinion that the order passed by the court is perfectly legal and valid, and this court finds no reasons to interfere. Accordingly dismissed. Next. Who appears as respondent? Who are the contesting respondents?
Normally practicing in the trial court of the concept of the practice in the suit also, not a normal.
Counsel for the petitioner is present. No representation on behalf of the counsel for respondents 1 and 2. The counsel for the respondent 1 for reporting a final opportunity. List is matter on 21st. No further adjournments will be granted.
Number 35.
Memo of retirement dated is filed with the counsel. Registry is directed to print the name of the party in the cause list on 13/11. A memo is filed stating that a memo of retirement is filed on 29/8/2024, wherein the petitioner had given NOC wakalat, and also all the documents were also written. In support of that, a printout of the WhatsApp messages has also been placed before the court. Considering the same, the is permitted to retire from the case, and this court has directed the registry to print name of the party. After taking the papers, the petitioner had not engaged the advocate or not taken any steps to prosecute the matter. Hence, the RPFC is dismissed for non-prosecution. Yes, next. How much is the amount?
Amount is 35,000.
35,000. That's the balance.
Balance is 65,000. They were given 35,000. 35,000. No, last time it was calculated and remaining balance was only 35,000. Out of which earlier 25,000 we had paid. Earlier 25,000 plus.
First of all, you take that PD, then file the memo. Today, when the matter came up, then counsel for the petitioner had handed over the DD for an amount of rupees 35,000. 35,000 drawn on KBC Bank, DD number 251800, dated 8/11/2020, is handed over to the counsel for the respondent. Then counsel for the respondent submits that that they have to pay. That there are still arrears. In that regard, we shall file a calculation memo before the court, and by serving a copy of the same, the counsel for the petitioner.
Because the record petition of the trial court has been withdrawn.
There is no stay in this. Then please wait. Let him come. File that when. This is matter on 21st. Yes, next.
2 weeks. 2 weeks. Once again, dates will be extended, and I will build an obligation for another time.
File it. Yes, next.
Petitioner is not ready for one-time settlement. She is seeking for monthly maintenance.
Your Lordship, in fact, we had submitted on the last occasion that the husband is willing to settle the matter for as a matter of one-time settlement, Your Lordship. The husband is also before this honorable court today.
One-side settlement of 10 lakhs.
Yes, Your Lordship.
How much is the monthly maintenance?
10,000. Arrears was not given from 2013.
Oh, 10,000. Per year, how much? 1,20,000.
In fact, Your Lordship, there are no parts in this case, Your Lordship. Initially, in the first round of litigation, the wife was denied maintenance, Your Lordship.
So whatever it is, now 10,000 is granted.
Yes, from the date of restoration, Your Lordship.
Why she is not interested? What is her age?
In her 60s, my lord. She's in her 60s, my lord.
And why she doesn't want? When she's getting 10 lakh rupees.
And there are two children, Your Lordship. One girl child is already married. The main child, in fact, he's looking after the main child and is making arrangements for his marriage also, Your Lordship. So what is his contention is, he'll settle the matter for whatever amount this honorable court directs him, Your Lordship. And as a matter of fact, Your Lordship, one-time settlement.
Why did you want enhancement of that amount of 10 lakh, 10,000?
Enhancement as well as, my lords, arrears, my lords, from 2013.
Arrears court will not, this court will not grant you arrears. Arrears, you have to have your own, mechanism to recover it. Tell your client, I will discuss this petition.
We keep the parties present.
Mr. Let her come. She is 60 years old. He's giving 10 lakhs. At a time you are getting 10 lakhs amount. So why is it good for her? It's a good deal for her. Both the parties shall be present before this court on 25th. Is it there? Any matter on 25th? No, on 25th. At 2 o'clock in the chambers. Yes, next.
And one card.
Yes.
Yes, ma'am. I call in question in this the annexure J. That is order passed in execution petition number 36/21 dated 21/4/2023, my lord. It has got a checkered history of 60 years, my lord.
So what is that order now?
That order has taken lord. Earlier, the gift deed has been got executed by the.
Those are the facts. What is the impugned order?
Impugned order is that the execution petition is not available.
Is dismissed.
Yes, sir.
What is the suit? Suit is for?
Suit is filed LC number 59/2064 by the donors, the donees, wherein one gift deed is got executed in favor of Dr. Modi on 15/3/1952, my lord. On the ground that he is one of the popular eye specialist for the construction of the eye hospital at Dharwad, it has been donated to him. But that the gift deed is also produced as annexure A, my lord.
Page number?
Page number 17, my lord. Annexure A.
Page number 7?
17, my lord. This gift deed has been given to Dr. Modi, and thereafter the position has not been delivered to him by the donor.
So, when is that the gift deed?
Joint family property.
Gift deed dated?
Dated 15/3/1952, my lord.
15/3/1952.
My lord.
No possession is delivered.
No possession is delivered, my lord. Thereafter, my lord, this Dr. Modi, Modi has filed suit in long cause number 59/64.
59/1964. What is a suit?
Suit is one for recovery of possession and also main profits, my lord. That suit is decreed on 2/7/1975, my lord.
2/7/1975.
1975.
Oh, decreed. Then?
Being included by that, this donor now filed RA number 20/2077, my lord.
20/1977,
my lord. That appeal is allowed and the impugned judgment and decree passed by the transport. Date is 16/9/1979.
16/9? 17/9?
And being ignored by that order, again this donor has filed RSA before this honorable court in RSA number 134/1985. That came to be dismissed, my lord. And thereafter the donor has filed review petition. That also came to be dismissed.
When is RSA dismissed?
23/8/1998, my lord.
And review?
Review petition is also dismissed. 21st July 2000.
2005. Yes.
Against which the donor has approached the Honorable High Court of Karnataka by filing SLP, my lord. Supreme Court has approached Supreme Court. There, the review petition is also allowed and RA is also allowed and remanded to this Honorable Court for disposal in accordance.
When is remanded?
On 6/1/2016, my lord.
Then?
6/1/2016, my lord. And thereafter, this RA is heard by this very honorable court. And while hearing, after hearing, again the donee has filed an application stating that they are ready to compromise because matter is of old year. For the last 40 years, they are fighting legal battle. Therefore, they are ready to compromise. And thereafter, the learned single judge heard the matter and compromise petition is accepted and the donees have paid 10 lakhs rupees. 10 lakhs rupees to the donor.
When compromise petition dated?
Compromise petition is dated.
That is order by the.
Order by the
until February 2020.
2020,
So what are the terms of the compromise?
wherein the RSA filed by them is dismissed and the judgment and decree passed in RA number 20 bar 20 bar yes ma'am. 77 is restored, my lord. That came to be intact because the seeking delivery of motion is set aside and that came to be restored, my lord. And it is thereafter the decree holders have had execution before the executing court.
What execution?
Stating that the possession given to him by the lower court is dismissed, therefore it is restored. Original facts are restored. That
Please come to the order in the order of this court in a compromise petition, page number. Page number?
99 onwards it starts.
yes, my lord. RSA, that is
Let's
NXA F.
let's read this order.
NXA F, my lord.
Internal page 6, para 4.
Yes, my lord. Learned counsel for the respondent submitted the aforesaid check to the learned counsel for the appellant. In turn, learned counsel for the appellant handed over the check to Sri Kishore P. Mane, administrator of appellant hospital. In view of the above, the order dated 11/2/2020 dismissing the appeal is recalled and accordingly appeal is dismissed as withdrawn. This appeal filed by the donor, and it has been withdrawn.
It is filed by the donor or donee?
Donee, my lord. Donee. Therefore, the earlier order passed in RA number 20, RA number 20 for 1977 is restored, my lord. That is intact because this was filed being executed by the judgment and decree passed by RA number 20 bar 77. This RSA number 134 bar 95 was filed and after remand the matter is settled in view of the matter that has been withdrawn. The withdrawn means now
So now the donor by receiving 10 lakh
10 lakhs
has accepted that he is entitled for recovery of possession.
He has passed away. Now we are the subsequent purchaser. Some layouts were found in that property. We are the purchasers of those plots. Now
It's all pending litigation.
2 minutes. What they say is, RA was allowed, suit was dismissed. So decree for possession came to be dismissed. Dhoni's decree for possession that came to be, that was originally decreed by the trial court. In the RA that was set aside. Now in the RSA that dismissal order has been confirmed in the RA. That dismissal order they want to execute. When there is no prayer for, when there is no decree for possession in their favor.
1 minute.
Lordship may kindly take.
No, 1 minute, 1 minute. Gift deed is dated 15/3/1952.
1952.
Then the donee has filed 59 of 64 seeking recovery of possession, which came to be decreed on 2/7/1975. Against that, the donor has filed RA number 20 of 1977. That came to be dismissed.
Hello.
RA is allowed by order dated 17/9/1994. Then again, the donee has filed RSA number 134 of 1995. Now, by virtue of the compromise, RSA is dismissed or allowed.
RSA is dismissed as withdrawn. Judgment of RA.
Then RA judgment is confirmed. That means the suit is dismissed.
Suit is not dismissed because it's in RA number 20 bar 1977. The judgment and decree passed in the long cause suit number 59 bar 64 is
set aside.
It's set aside, my lord. We set aside and that means
so please understand RA number 20 of 1977 is in favor of the donor.
Yes, ma'am.
In favor of the donor. Against that RSA is filed by the donee.
Yes.
So donee, now they have compromised and the appeal filed by the donee is dismissed. Withdrawn. So now whatever that is in favor of the donor is what is holding the field. What is in favor of the donor? That your suit for that recovery of possession is dismissed, and they have a decree in RA.
That has the non-suit number.
No, please come.
Suit for possession and
In view of the order dated dismissing the appeal is recalled, accordingly is dismissed as withdrawn. So, in the eye of law, this RSA is withdrawn. It is not there. What is the order in RA?
RA means whatever the delivery of possession is passed, that is set aside, and main profits is set aside.
Who are you? You are the donor or the donee?
I am donor, my lord.
But then RA is in their favor.
RA is in our favor.
Decree for possession was in favor of donee.
Correct.
Donors filed an appeal.
RA.
That
RA came to be in their favor.
Allowed, and suit for possession is now dismissed. RA allowed, suit for possession stands dismissed.
That's in favor of the donor.
Yes, ma'am. That is an order of dismissal of suit.
That's what it is in favor of the donor, is it not? Donee has filed.
Yes. But what they want to say is now they want to recover possession through that decree. Dismissal order, they want to execute an order of dismissal of suit, which is not permissible. What they should have done is, in this compromise itself, they should have put a term regarding possession of the property to be re-delivered by the donee to the donor. But in fact, the suit itself was
possession. It is not, because that cannot be. Because
donee himself
for withdrawing the petition, the donee was happy with that 10 lakh rupees. Then it means it will be with the donor. The position will be with the donor.
Yes, position remains with him is what they say. Now they want to execute it against subsequent purchasers.
How can it be? It's not your suit.
60 years has been enough. Therefore, some third party have created.
Please come to the impugned order.
And they have created interest. They are trespassers.
Please come to the. Then your remedy is elsewhere, not in execution.
27 of the impugned order.
Page number.
Page number. It starts from 120. It starts.
Yes.
Internal page number 10. Para 27.
Come to para 20. Please read para 20.
Point. That has been answered in the negative, my lord.
Read.
Yes, sir. The present petition is filed under Order 21 Rule 35 CPC seeking execution of the decree passed in RA number 20/1977 dated 17/10/1994. The petitioners are seeking to hand over possession of disputed property from the JDRs. On going through the averments of the petition and objection filed by the JDR number 2 to 4, it can be seen that
you have purchased a property from whom? You have purchased a property from whom? How are you called as a JDR?
That is how they have arrayed me as a party in the execution petition. There is no decree against us.
You are not party in any proceedings.
Yes, understood. Yes, next. I'm going through the, please read paragraph 21.
Yes,
I'm going through.
It can be seen that DC Dr. Modi had filed a suit in LC number 59/64 on file of this court seeking position on the basis of the gift deed executed by one Shankar Desai, the grandfather of the petitioners herein. The legal battle which commenced in the year 1964 was fought till 11/2/2020. Ultimately, the matter came to be compromised before the Honorable High Court in RSA number 134/95 as per compromise. The LRS of original plaintiff received an amount of 10 lakh from the petitioners herein and gave up their claim for the suit property. Accordingly, RSA number 134/95 was disposed of on 22/2020, whereby the judgment and decree passed in RA number 20/1977 was restored. The ultimate result of litigation was dismissal of suit filed by the original plaintiff. The operative portion of the RA 20/1977 being relevant is extracted below. Appeal is allowed. The judgment and decree of the trial court are set aside.
Yes, I've seen. The trial court was perfectly right. How can you execute a decree? Are you a decree holder?
In that, Your Honor,
You are a decree holder. As good as a decree holder according to you. Who are they?
they are third party unnecessarily they are responsible.
So like against the third party, you will execute a decree.
In respect of the property, 20 guntas, I initiated in view of the.
You cannot. Please come.
May I make one more substitution? If this honorable come to the conclusion that this CRP is not available, I may kindly be permitted to initiate independent proceedings. Permission.
That's always it. You are at liberty if you want to take any action against them.
You are third party, they are trespassers, I cannot.
Whatever it is, whatever is the remedy available to you, even that's what the file court observed also, that you can have any remedy available. You can have
If there is some observation, it is helpful to me and so that I will file independent.
Is it getting recorded?
Independent
What you should
against
do
the
is,
third party, my lord.
first, the moment I start, first on it, switch on now. There need not be a password for it. You have to just click it. Huh?
We are giving one document. That we have to navigate. That is
What is so simple, all of you are making it complicated. In Bangalore, it is working like anything and they're able to do the work. Such passwords every minute are not required. Just have to switch on this. There will be only one ID. On that, it is already open.
The respond number
Agree with the orders passed in.
The respond number 127
Execution number 36 of
trespassers, they are
2021,
illegally in the
dated 21st April 2023. The petition is before this court. The petitioner herein has filed a petition under Order 21 Rule 35 of the CPC, seeking to hand over the portion of disputed land bearing RS number 466 of 1/1 measuring 20 guntas, situated at Gadag, Vettagiri from the judgment debtor number 2 to 7. It is a case of the petitioner herein that he is the owner of an extent of land measuring 20 guntas. He had given the said land he has executed a gift deed in favor of one Dr. M.C. Modi for construction of a hospital. And according to the donee, as on the day possession was not delivered to him. Thereafter, he had filed LC 59 of 64, seeking recovery of possession that came to be decreed on 2/7/1975. Thereafter, the donor had filed RA number 20 of 1977 that came to be allowed on 17/9/1994. Against that, RSA number 134 of 1998 is filed. 1995 is filed. In that RSA, the parties have, in that RSA also came to be dismissed. Then the matter was carried to the Honorable a review is also filed. Thereafter, the matter was carried to the Honorable Apex Court. Honorable Apex Court has set aside the order and remanded the matter to this court. After the matter is remanded, parties have entered into a compromise in RSA number 134 of 1995 on 20/2/2020. As per the same, the donor had paid an amount of rupees 10,000, 10 lakhs to the donee, and the donee had submitted before the court that he has no, the RSA may be dismissed as withdrawn. Now, by virtue of the fact that the RSA is dismissed as withdrawn, the order passed in RA number 20 of 1977 is restored, which is in favor of the donor. Next part. Thereafter, the present execution petition, that's EX 36 of 2021 is filed, stating that some people are in unauthorized possession of this property. That is, all the respondents 1 to 7, they are shown as judgment debtors. According to them, as it is a case of the donor that he is the decree holder and the possession should be, and they should be evicted. The judgment, the persons who are in eviction, who are in possession of the suit scheduled property have to be evicted and they should be placed in possession as the suit is for recovery of possession. That application came to be dismissed by order impugned, wherein the court observes that the judgment passed in RA number 20 of 1977 is held that there was no transfer of possession by the donor to the donee and therefore the gift is invalid. Now the petitioner stating that the JDRs have illegally come into possession of the property are seeking recovery of possession from the JDRs. Even if it is accepted that the JDRs have illegally come into possession of the property, the execution petition seeking recovery of possession is not maintainable unless there is a decree for possession. The suit filed by the donee has been ultimately dismissed in view of the compromise and there is no executable decree against the JDRs and accordingly dismissed. Expert. When counsel appearing for the petitioner, defendant, oblique donor submits that in view of the compromise and the withdrawal of the RSA and the judgment and decree passed in RA is restored and he is a decree holder. And as the suit is for recovery of possession, he wants to recover possession from the people who have encroached the land without any manner of right and title. The trial court, without considering all these aspects, had dismissed the petition. Next, when counsels appearing for the JDS as arrayed by the decree holder submits that they were never parties to the suit and they cannot be considered as JDS. It is submitted that the petitioner herein cannot execute a decree against the respondents who are not parties to any suit and they are the purchasers of the property. The court has rightly dismissed the petition and the decree is not executable against them. Next part. Having heard the counsels on either side, there is a material on record. The suit is filed for recovery of possession from the donor by the donee. Both the donor and the donee have compromised the matter. And the sum and substance of the said compromise is now the donee will not recover, has given up his claim by recovery of possession. In that case, there is no decree in the eye of law which can be executed. And a judgment and decree between two parties is not that. Now, by virtue of this execution petition, the defendant in a suit who is a donor, according to him, he is the decree holder, which is unknown to law, and he cannot be termed as a decree holder. And the relief that is sought by the plaintiff of recovery of possession, where the possession is with the donor, that is the petitioner who calls himself as a decree holder, cannot seek for recovery of possession by virtue of an order in RA number 20 of 1977, the trial court had rightly dismissed the petition and held that they cannot execute the decree, and there is no decree in the eye of law to be executed. If at all the petitioner feels that he is the owner of the property and some third parties have encroached into in the property belonging to the petitioner, he is always at liberty. He can always file an appropriate application, provided application before the appropriate. He can initiate appropriate proceedings before the appropriate forum. Accordingly, this petition is hence in the considered opinion of the court. The trial court had rightly get together and rightly dismissed the petition, and this court finds no reasons to interfere. Accordingly dismissed.
In that event, my lord, the time consumed in a wrong forum may be excluded.
What wrong forum? You cannot have any relief from that decree. Oh.
In IA number 2/23 for the modification is your lordship. This honorable court has granted the conditional entry mode saying that we have to deposit 60,000 arrears. However, we have deposited it in the execution proceedings instead of main matter. So the page number 4 and 5 is a deposit of the arrears.
How much you deposit?
72,000, your lordship. In fact, the entry order was to deposit
72,000 after the order is passed. Yes.
Since
My instructions are, last acquisition matters, direct them to file a calculation now.
Not filed.
your lordship, with respect of the calculation, today my client has given me the instructions. After passing of an entry model, he has not paid.
Please trace it. Then counsel the petitioner shall file the calculation memo by 20th. This is matter on 21st.
Then file the memo of calculation.
And the counsel for the respondent shall also file the memo of calculation by 20th, and this is matter on 21st. Yes.
You want to conduct by the Son of Morning has not deposited as it was a conditional order.
No, that we will do it on 21st. We'll do it on 21st. Yes, next. Yes, amount is paid as per the order dated 19 to 2020.
Total amount as on date is 2 lakhs, my lord, arrears, entire arrears. And out of which 40,000 was deposited before this honorable report.
No,
And
there is an interim order dated 19 to 2024. There is a due of arrears of maintenance, sum of rupees 1,40,000 according to the resident petitioner. Has paid 40,000 today. Parties seek further time to find out feasibility. Relist this petition. By then petition shall pay substantial sum of arrears.
They have initiated recovery proceedings in the court below, my lord. And that is dated.
So you don't have a stay in this. Then let's proceed with the matter. Yes.
Already, so far as this petition is concerned, I don't have any grievance to pay for the daughter, my lord.
No. First of all, what is the order? Order of the trial court.
Maintenance of 3,000 is ordered to the daughter. Yes. And maintenance of 5,000 is ordered to the wife. Aggrieved by this, the petition is before the son.
Why your wife is not entitled for 5,000?
Lord, she is more qualified than me. She is a postgraduate and also earning, my lord. She is working presently in Fatima High School of Hubli. It is admitted in her evidence itself. But however, she denies it, saying it's a honorary post.
What is her position in that Fatima Institute?
She's a teacher. And even before marriage also, admittedly she was working in KCD College, Dharwad.
Please come to the order. What is the discretion of the court on that?
Para 33 minutes. As discussed here in Supra. 33 minutes. Page 18. Internal page 18 of the court. Page number 26 of my revision memo.
What is that in Kannada?
Please, I shall read memo.
Yes.
Please. ಮದುವೆ ಪೂರ್ವದಲ್ಲಿ ನಾನು ಧಾರವಾಡ ಕೆಸಿಡಿ ಕಾಲೇಜಿನಲ್ಲಿ ನೌಕರಿ ಮಾಡುತ್ತಿದ್ದೆ. ಸರ್ಜರಿ ಕಾಲೇಜಿನಲ್ಲಿ ನನಗೆ ಪ್ರತಿ ತಿಂಗಳು ರೂಪಾಯಿ 30ರಿಂದ 40 ಸಾವಿರ ಸಂಬಳ ಬರುತ್ತಿತ್ತು ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಈಗ ನೀವು ಹುಬ್ಬಳ್ಳಿಯಲ್ಲಿ ಫಾತಿಮಾ ಹೈಸ್ಕೂಲ್ನಲ್ಲಿ ಟೀಚರ್ ಕೆಲಸ ಮಾಡುತ್ತಿರುಕೊಂಡಿದ್ದೀರೆಂದು ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿಯು ತಾನು ಆನರರಿ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ಅದರಿಂದ ನನಗೆ ತಿಂಗಳ ರೂಪಾಯಿ 20,000ರಿಂದ 30,000 ಸಂಬಳ ಬರುತ್ತದೆ ಎಂದು ಹೇಳಲು ಸರಿಯಲ್ಲ. She admits that she is working in Fatima High School, Manoj, at present, but she says it's an honorary post and she's not getting any income from it.
Why you should work honorary without when you are
I have been given an opportunity to show my talent for a period of 1 year. If I successfully complete 1 year, they'll be giving a fixed amount.
This order is passed when
2023.
This order is passed on 2023. Now it's already you have completed 1.5 years.
They gave me only after completion of a year. They had assured me monthly 5,000 projects. At least 60,000 they have to give me. They gave me only 30,000 back to cash, not even in bank or anything. Nothing is being given. Since 30,000 was given, I have not gone over there now back. I'm continuing pursuing my studies, Your Honor, so that I can get a better job. And earlier to the marriage, I was getting 30 to 40,000. No document is produced, and I was not earning also, Your Honor. I have clearly said that I was not earning that. Because I have clearly made my denial, Your Honor. My child is now 5 to 6 years old. I need to send her to the school. I need to maintain.
What is your income?
I was working as field assistant in sugar factory, Manoj, prior to the institution of all these proceedings. Once my wife left me, I suffered through cardiac arrest in the year 21.
What is your income?
Now I am not working.
As per the order of the court.
It is their contention that I am earning 70,000, but no material.
Both the parties have filed the respective statement of assessment before this court by 25th. This is matter on 28th. Yes. Why?
Party is not protected.
You want party compromise copy?
Compromise. Even then the merits is not also. Respondent is working at Bangalore. Here about the 500 kilometers from the Bangalore to Belgaum. She is working at Jamkandi. She is also constable. He is also constable in the reserve police. She is working at Jamkandi. Then 3 to 3.5 hours she is reached the Belgaum. Early in the morning she sits in the free bus. The government has given the.
And what about you?
I am the respondent. I am the constable in the reserve police Bangalore. Commissioner Office Bangalore. She is also working, he is also working. And compromise between them.
Yes, why is the client not in touch?
To withdraw the present petition. Seeking to withdraw the present petition.
Instead of withdraw, you give the direction to the court.
So when do you want? When will you get instructions?
Consider the same. Take 27th is fixed date for appearance and take 1 day.
21. This is matter on 21st. At the request of learned counsel, the petitioner. No further time. So what earlier granted is extended till then. Yes. You are for the husband or wife? How much is the amount granted?
On the last before my senior friend submits merits, on the last occasion merits, they have made the submission that there is a compromise thought has been taken place. And even I have not received.
I had called Manoj and informed the petitioner. I have asked him. He said Manoj,
but I don't have any instruction. But I will take the instruction and
both the parties will appear before the court on 28th in the chambers at 2 o'clock.
Please, move.
Yes, next. Yes.
hearing, filed the suit seeking the relief of declaration, stating that the GPA was fraudulently obtained by the defendants. Thereafter, by using this GPA, they said it in their own name, behind the back. The total sale condition was fixed at the rate of 2.50 lakhs per gunta, and it came to the tune of 83.50. They paid 13 lakhs, and just to avoid the payment of remainder, they created this GPA, and on the strength of GPA, they created the sale deed in their own name itself. And on the strength of that, their name came to be mutated. But in the meantime, what they presented to the plaintiffs is that since there was a suit pending and plaintiffs were in dire need of the money, they were insisting. Therefore, they said that they will expedite the matter by obtaining GPA. And this was precisely the understanding given. But this GPA empowered this one GPA holder to also alienate the properties. Instead of selling it to somebody, they sold to themselves and they did not pay anything. So there is agreement of sale which is admitted. There is GPA that is also that they admit the agreement, and there is a sale deed. So what has happened is that they have defrauded the plaintiffs to the tune of.
What is this IA first that you can tell?
Please.
IA. What is IA first?
IA is filed now by the defendants, stating that the suit is barred by the law of limitation under 1711D. They state that the sale deed is of the year 17 and you filed the suit in the year 2021.
Sale deed is of the year?
17.
70.
2017, and therefore the suit is filed in the year 2021, so it is barred by law of limitation. We made a submission before the court that it is a mixed question of law and fact. It needs evidence.
What did the court do?
Court said that court has even recorded a finding in favor of the plaintiffs in para 46, 47, page 33, running page. It says that it is mixed a question of law and when cannot be rejected. That's what it says. But eventually it rejects. Kindly see para 46, page 33. It is a settled position of law.
It is rejected. It is rejected.
Plaint is rejected, but it says that it cannot be rejected here because it is a mixed question of law and fact.
So how can you find a CRP if the plaint is rejected?
It is a case decided. In case IA is filed seeking rejection of the plaint,
this is
and the plaint is rejected, then it is case decided within the meaning of 115. Section 115, if the case is IA is allowed and suit is rejected, plaint is rejected, it amounts to case decided. But if the case is rejected, then it does not amount to case decided, and therefore writ petition is maintainable in that case. Therefore, office has not raised objection because here before these objections were raised by the office, and that is time and again clear. So it is a case of case decided because IA is allowed and plaint is rejected. Therefore, I am now out of the court. Hence, the remedy open to the plaintiffs is under 115 by way of CRP only.
When is a suit is filed? When is an appeal filed against that rejection of plaint?
This is the IA now, which is filed against.
That's what I'm saying. When the IA filed under order 7 to 11 is allowed and your plaint is rejected, then what is to be done?
CRP, that's what I am saying.
Appeal doesn't like.
No, it is not appealable order. It comes under 115 precisely. And if it is
an application seeking rejection of plaint is dismissed,
then writ petition is maintained.
Not writ petition, then the CRP lies here.
No.
It is an appealable order. Please take that. It is an appealable order. How can a petition lies? Petition doesn't like. It is like
allowed therefore CRP is.
Look at the legal position and come. Look at it's very clear. Now, by virtue of this order, your plaint is rejected. And it is like a first appeal. You have to file a regular RA against that, not a revision. Look at it tomorrow.
Yes. In case that eventually I may be permitted to withdraw. Permission.
Agreed with the order of rejection of plaint. The plaintiff is before this court. The CRP is not maintainable. He has to file a regular appeal against the said order. In view of the same, the petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy available to him.
Yes.
Yes.
Are the proceedings from Karnataka to Dharwad?
All the original document returned to the petitioner immediately. Yes. One minute. Let me just look at it. You want MC pending on the file of the Khanapur to Dharwad. What is the distance between the two?
53 kilometers.
53 kilometers. When is the MC filed? 2023. What is the stage of the MC?
She has appeared. She has engaged the council.
No, evidence has not started.
Not yet started.
And what is it pending at Dharwad?
Proceedings under 498 and DP Act are pending in Dharwad. Dowry Prohibition Act.
498 is concerned, my lords, the further proceedings are stayed by this one.
Anyhow, but we'll consider the convenience. What are your grounds?
What I'm trying.
Let him talk. Yes.
It's from 2018, she left the company of Lords husband. From then, my lords, she is residing separately. And in the, till 2023, my lords, he made all the efforts to take her back. My lords, after my lords filing the petition for conjugal rights, she started filing, my lords, all these cases.
It's on the merits of the matter, please come. The present petition is filed, seeking transfer of MC number 105 of 2023, pending on the file of the Senior Civil Judge Khanapur to Principal Judge Court Dharwad. The facts of the case are: the marriage has solemnized between the parties on 14/3/2016. In view of the differences between the parties, the wife is staying at Dharwad. The husband has filed MC number 105 of 2023 before the Senior Civil Judge Court Khanapur. The wife had lodged a complaint under section 498A 323, 504, 506, Federal section 149 IPC, and section 3 of the 3 and 4 of the Dowry Prohibition Act in crime number 99 of 2023. And after investigation, they filed a charge sheet, that is CC number 33 of 2023, on the file of the second additional civil judge and JMFC 2, Dharwad. The wife had also filed criminal miscellaneous number 17 of 2024 under section 12 of the Protection of Women from the Domestic Violence Act before the principal civil judge and JMFC Dharwad. Land counsel appearing for the petition submits that the distance between both the places is about 50 kilometers. Already 2 cases are pending before the courts at Dharwad, and this matter, hence this MC is also transferred to the courts at Dharwad. It would be convenient for the wife. Next para. Land counsel appearing for the respondent husband submits that the wife had filed a complaint under 498A, which is stayed by the High Court in a criminal petition. It is submitted that she has filed the cases as a counterblast to the MC filed by him. It is submitted that no grounds are made out for transfer of the petition from transfer of the MC from Senior Civil Judge Khanapur to Dharwad. Considering the submission of the having heard the counsels on either side, there is a material on record. The undisputed facts are before the courts at Dharwad, 2 cases are pending. One is a complaint under section 498A.
3 cases.
And another is the petition filed by the wife, that is criminal miscellaneous 17 of 2024 under section 12 of the Protection of Women from Domestic Violence Act. The wife is staying at Dharwad at her parents' place, and the court where the MC is pending is about 50 kilometers. Considering the inconvenience to be caused to the wife, and as already 2 cases are pending on the file before the courts at Dharwad, this court deems it appropriate to allow the petition. Accordingly, the following: so and so is withdrawn from so and so, and accordingly allow. Next one.
Office has put a note that they are not collected from summons. Last time inadvertently we were under the impression that we were directed to serve a copy of the petition to
the
Now
council.
take, now you take. Now you take. It is submitted that though an order is passed on 25/10/2024, the due to some communication gap, they couldn't take out hand summons on the counsel appearing to the respondents before the trial court. The petitioner, counsel, the petitioner submits that now they will take hand summons to the counsel appearing to the respondents and they will file a memo to that effect. This is matter on 28th. By 27th, memo shall be filed in that regard. Yes. Yes.
Petitioner, my lord. The petitioner is a respondent in the suit below, my lord. Being aggrieved by rejection of application under order 7 with 11 AD.
Is it the matter which is heard on the last occasion?
Please,
Court wanted to dismiss it. You sought for time.
please. Lord, I have consulted the parties this order that you are there.
On your merits, yes, please come.
But my only contention is that, my lord, while considering the application under order 7 to 11, the courts shall look into not only the plaintiff government, but also the documents produced along with the plaintiff. But in this order, my lord, the court has mechanically passed order only by looking into the plaintiff government's.
What is your case? What is your case? Why the plaintiff should be rejected?
Please, my lord. Already there is a partition way back in the year 1990, my lord, which is admitted in the plaint. He says there was partition in 1990 and equal shares were allotted in all the properties relating to the family. However, he came to know only after 32 years that one property, his share was not allotted and he was ignorant for all these 32 years. Now he has created an imaginary cause of action, clever drafting, saying that he came to know only after 32 years. So now he is instituting this.
Let's see the plaint.
Please. Plaint is at page number 18.
It's the law.
18, my lord, 17. It starts at 17. Para 3, my lords. The plaintiff defendant number 1 and their late brothers by name so and so, all sons of Irappa, were the members of the joint undivided family, and this property along with other properties of the family were the joint family ancestral undivided properties of the family of plaintiffs and defendants. Plaintiff and his brothers, according to their convenience, got the family properties divided and also got equal share. But unfortunately, plaintiff was not given with any share in the suit A property. There was only one property. In fact, the plaintiff is also entitled to 1/4 share in the suit Schedule A property. At the time of effecting oral partition, a worthy was submitted to the revenue authorities. In the worthy, it is wrongly submitted that the share of Basappa has 4 acres in the suit Schedule A property, whereas he was allotted with 2 acres of the land, and the plaintiff was allotted with the 2 acres of the land. Venkana and so on Hanmappa were allotted with 2 acres each of the land, but through inadvertence and oversight, the share of plaintiff is missing, and it is not mentioned in notation entry of 2005 of Hebard village in the Vardi, which was submitted on 25/11/1990. And basing on the wrong Vardi, notation entry is certified, and share of the plaintiff is not shown. In fact, plaintiff is also entitled to 2 acres in the land, original land, number so and so. Total measuring area. Plaintiff with an
And what are the documents that are filed along with this one?
My lord, those documents are not at all referred to.
Where are they? That should contain.
Please, my lord, it is not.
Oh, if they are filed, what are the documents according to you are not considered?
My lord, according to me, it is a notation entry, my lord, of the year 2005, basing on the partition 25/11/19.
Where is
the checklist is not produced. Unfortunately, checklist is not produced.
Then go to produce it. This is for the next week. On 27th, no further time. Yes.
47?
Yes. Yes.
I may find before the trial court for rejection of aid is rejected. I have called in question the interim order produced.
What is the suit for?
Suit is one for actually for injunction, my lord, but in the prayer column they have sought declaration and injunction also, my lord. In fact, the suit schedule property is joint family property of the plaintiff and defendant. In fact, as per annexure F.
On what ground the suit has to be rejected?
Because there is partition among them. They are plaintiff and defendant together are joint owners in respect of suit schedule property 10/7 measuring 3 acre 37 gutta. And their names, there was a partition among them. I have produced annexure F, my lord. Annexure F. And they have effected partition way back in the year 1982, my lord. 1982. 26. Yes, my lord. 26/1982. There was a mutation entry certified 1244, wherein the plaintiffs and defendants together are joint owners. Have effected partition way back in the year 1982. Still then they have suppressed this fact and approached the court stating that they are the full and absolute owner of this entire property bearing 3 acre, bearing 10/7 measuring 3 acre 17 meter. And the learned magistrate in his order at external page number 42, internal page number 6, my lord, has stated that the plaintiffs have not admitted the ME number 1244. Though there is a documentary evidence, the revenue authorities, while discharging their owner's duty, have taken the worthy, joint worthy filed by plaintiff and defendant. It's an acquisition of right by both the parties. Both are co-owners, both are joint owners. Still then.
What is your IA? IA for rejection of claim?
IA is page number 14, my lord. It is plain, my lord. Annexure A is the plain, my lord. And IA for rejection is annexure C, my lord. Annexure C, external page number 29, wherein we have sought for rejection of the claim on the ground that suit itself is not maintainable.
Then also the petitioner placed before this court the translated copy of IA file, and the affidavit that is filed. This is matter on 25th.
Yes,
Next.
little more time. At least 2 weeks, my lord, because I have to get it translated.
Court has to understand without that why the stay will be granted.
At least 1 week. At least.
Take it tomorrow also and hear it tomorrow.
No, my lord, at least 1 week.
No. Without understanding the case, no stay. Yes. Okay. Yes, 48.
Yep, it's got it.
Page number 13 is my prayer, Lord. Transfer
Woke up to Mudol. What is the distance between the two?
65 minutes.
65. Any other cases pending there?
Yes,
Huh?
Wife petition filed by the wife or the conjugal.
The husband has filed for divorce lots.
Husband filed by.
This is a petition filed by the wife. MC is filed by the husband. At Gokak. Any other petitions are pending at Mudol? Mudol. No. Yes. What are your submissions? The present petition is by seeking transfer of MC number 101 of 2024, pending on the files of principal senior civil judge, Gokak to the senior civil judge and JMFC at Mudol. The facts of the case are that the marriage had taken place on 7/6/2023. You know the differences between the parties. The wife started residing at the parents' place at Mudol. She has filed criminal miscellaneous. She has filed a criminal miscellaneous number 292 of 2024 before the principal civil judge and JMFC court at Mudol, seeking maintenance under section 12 of the Protection of Women from Domestic Violence Act. As a counterblast, according to the wife, husband has filed MC number 101 of 2024 on the file of the family court, Gokak, seeking divorce It is the case of the wife that the distance between both the places is about 65 kilometers. 65 kilometers, and it's very difficult for the wife to travel. Land counsel appearing for the respondent submits that the no reasons are stated for transfer of the petition from Gokak to Mudol. Next para, having heard the counsels on either side, there is a material on the court. Considering the fact that the distance between both the courts, both the places, is about 60 kilometers, and already a criminal miscellaneous is pending at Mudol. This court deems it appropriate to allow this petition, and accordingly the following so and so is withdrawn from so and so and transferred to so and so accordingly allowed. Next part.
Not husband filed MC number MC note before the principal senior civil judge Gokak, not family. Filed note principal senior civil judge Gokak.
Just next 49.
49.
Husband petition was included order at page number.
How much is granted?
7,000 has been granted.
What is your income?
My income is 12,000, so I have the service certificate.
3,500. The 4,000. The land counsel submits that its income is the husband's income is 12,000, and court had granted an amount of rupees 7,000 as maintenance. Considering the submission, they should still call for the proceedings on the condition that the husband should continue to pay an amount of rupees 4,000 by 5th of every succeeding month, and shall continue and shall pay the arrears at 4,000 from the arrears at 4,000 within 8 weeks from the date of receipt of the copy of the order. Same, either of the two. If they are not complied with, the order stands vacated without further reference to the court. Issue emergent notice. This 50. Very good. And on such deposit in all the cases, whether I tell or not, the wife is at liberty to withdraw. Yes. What is your income?
Entire family income is 40,000. Entire income is 40,000. But the eligibility R1 to R3 Malad, certificate issued by the Malad, the deputy Tashildar, stating that the total income of the family is Malad 40,000. Without considering the Malad, the
total income of family is 40,000.
He is working is aggregated fully. There are 6 members in the family.
40,000 per annum.
Per annum.
Let's see.
Already Malad diverse from the
Let's see where is the finding.
Finding Malad. Para 17 para women eligible.
Para
17. That is the evidence of the RW2. The other of the Maladi petition. One thing is he also filed the suit for partition against family member.
Also, the petition submits that the annual income of the family is 40,000, and court granted an amount of rupees 15,000. 15,000, that is 10,000 to the wife and 5,000 to the child. Considering the submission, the petitioner shall deposit shall pay an amount of rupees 2,500 to the wife and 2,500 to the child.
More submission also. During pendency of the petition, the already deposit 2,70,000.
It is submitted that he has already deposited 2,70,000 in which proceedings? In the has deposited 2,70,000. So the petitioner shall continue to pay 2,500 to the wife and 2,500 to the daughter by 5th of every succeeding month, or else the stay granted by this court shall stand vacated without further reference to the court. Notice. Next. Yes.
Of this honorable court may have served the copy and advocate who is representing the respondent in the trial court.
You file the memo?
I filed the memo.
What is the name of the advocate?
But the acknowledgement, my lord, Prashant P. Patil.
Prashant,
P. Patil, my lord.
in the name of Mr. Prashant V. Patil, as per the order passed for this court, the petitioners take notice on the counsel appearing to the respondent before the trial court and filed a memo to the effect. Notice to respondent is self-sufficient. Put in the name of so and so in the cause list. This matter on Monday, not Monday, Tuesday. Interim order only granted is extended till then. Is next.
From the Court of Senior Civil Judge and KMC Devika, which is in Jaipur district.
What is the distance? Distance.
Distance is more than 200 kilometers.
400 kilometers.
So the petitioner has asked for the tickets.
Then counsel for the petitioner submits that. The then counsel for the petitioner submits that. The husband has filed MC number 2929 of 2024 on the file of the JMFC court. Or how is it spelled? Mudde Bihal. And the wife is residing at Ramdurg. And the distance between both the places is more than 400 kilometers. Considering the submission, there shall be stay of all further proceedings. On the file of so and so, in the next state of hearing, petition is permitted to take out hand summons on the counsel appearing for the respondent for the trial court and shall file a memo to the effect. This is matter on 3rd of December. Not 3rd, on 10th of December. Yes. Next. Yes. Oh.
Number 24, pending before the senior civil judge Kadur to the court of second additional civil judge and JMFC Ranebennur, wherein she has filed a petition under section 125 for maintenance. Husband has filed.
What is the distance?
Distance is 370 kilometers.
Husband has filed MC number 50 of 2024 on the file of the senior civil judge and JMFC Kadur. And the petitioner is a resident of Ranebennur. Is a resident of Ranebennur and the distance is more than 400 kilometers. 340 kilometers. Considering the submission, they shall be stay of all further proceedings. The petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to the effect by 9th December. Yes.
Number 54.
Yes. Petitioner is a respondent. Where the wife and children have filed a petition under section 1.
How much is granted?
No, it is a different issue. Wife and children have filed a petition under section 125 CRPC. And in the said petition, the husband has disputed the paternity of the children of whom they are claiming a maintenance against the present petitioner. He has filed an application for examination of DNA. That was rejected by the trial court, holding that 125 CRPC proceedings are summary and that cannot be tried.
Notice to that.
Further proceedings may take place. Since the court is insisting day to day that is proceeding. And now the matter is posted for arguments before the trial court.
When was this application filed? When was it? When is the order passed?
Order is passed on
3/8/2024.
24/8/24 minutes.
Then what are you doing in the last 2 months?
On 29/10, I have filed the application, that is petition.
Let's see, what is it?
Order is at page number 34 minutes.
Then what is the law on this?
Submission another petition he has filed for divorce.
No, the court has said that under 125, this cannot be done. So what is?
Where is the order? Where is the order? It is at page number 34.
Yes, I'm looking at it.
Yes.
Come to the reasoning part.
Yes. Point number 1. The petitioner is a filed petition under section 125
seeking maintenance from respondent. Petition number 1 is said to be the wife and petition number 2 are said to be the children of petition number 1. Respondent number appear before the court and file objection denying the contents of petition and also content petition number 2 are not bound to you. That is the dispute matter. By filing this application second panel, respondent is seeking assistance of the court to undergo a DNA test to dispute the paternity of the petition number 2 and 3. It is a settled law that petition under section 1 is a summary proceedings and the application filed for DNA test cannot be allowed as a general routine. If there is a strong prima facie case made out by respondent apart from mere allegations, court can permit the parties to undergo DNA test. Moreover, in petition under section 125, the court will not decide about the status of the parties, and it is open for the respondent to file necessary civil suit if he is not of the opinion that petition number 2 and 3 are not bound to him, and if he is seriously challenging the paternity of petition number 2 and 3. Merely on the allegations, if the court permits petition number 2 and 3 to undergo DNA test, it will certainly affect the future of minor petitions, which will have a social impact. Moreover, respondent number has not let his evidence to prove his contention by leading evidence and to get himself cross-examined by petitioner.
Yes, so you have please convince the court on this application basing on some law, some judgments.
Yes, there is a latest judgment on this point. If the parties are disputing about the paternity of any of the children minorship, then the court has to refer them, that is the persons for DNA test. Latest judgment by Justice H.P. Sandesh. A recent judgment on the point. Very much because as far as
Supreme Court judgment, you please. Just this matter when tomorrow, Tuesday, Wednesday, whenever you want.
Tomorrow, may I request tomorrow?
Tomorrow.
Please.
This is matter tomorrow. At the request of the counsel. Where is the counsel for the respondent? Any interim order in your favor? No representation for the respondent. Counsel for the petition is present. This is matter on 10th of December. Interim order earlier granted is extended till then.
Sorry, not interim order is vacated.
It's vacated on this is matter on that day. No interim order. Yes, next.
Yesterday this matter was taken in chamber. The parties had agreed before your lordship that they would live together. Now, my lords, both the parties have turned out. Now the husband has put up some restrictions. And why? But she's not agreeing. They're ready on marriage, my lords.
Yesterday, your lordship.
What are his conditions now?
No such condition.
Huh?
Simply there
is no condition. Mike, please.
Yesterday, my lord, they agreed for some terms. Subsequently, my lord, both have done, my lord, from those terms.
No, what he is saying.
Lord, he's saying, my lord, now, what he said yesterday is, they have already, my lord, they have already, my lord, ready for the marriage of their sister within two months. But he's saying, if they are performing the marriage, he will not cooperate with that. And if he will look after the sister, and he will search for a bridegroom, and he will take care of it. And now he is saying, and she should not visit the residence of her matrimonial. She should not visit the matrimonial house of her maternal uncle and aunt, and they should not visit.
Is it so?
क्या बोल रहे?
वो अपने अंकल के करना है जाना.
और अंकल ನಿಮ್ಮ ಮನೆಗೆ ಅಂಕಲ್ ಆಂಟಿ ಬರಕ್ ಬೇಡ.
ಅಲ್ಲ ನೀವು ಮದುವೆ ಬಗ್ಗೆ
ಬರಕ್ ಬೇಡ.
ಅವ್ರ ಮದುವೆ ಬಗ್ಗೆ शादी के बारे में बात.
That's the reason Lord.
कर रहे हैं ना, करने दीजिए.
इंटरफेयर करने के बात नहीं. कल क्या बोले थे आप चेंबर में? वो बहन के साथ आएगी, उसके लिए आपको कोई ऑब्जेक्शन नहीं है. नंबर 2, अगर उनके शादी के लिए जो भी आपके साथ होता है तो आपको पैसे देंगे, तो तो फिर और कुछ बात करने की क्या जरूरत है? First of all, I don't think these people have no confidence on each other.
That is the only thing.
Please come, I'll pass orders on the merits. No, it's okay, it's okay.
What happens, that's the only thing. If they have put it in writing, I could have convinced, he has not said anything.
When they have no faith,
Then it's better, then it is a restore, conjugal rights has been restored, this is the order they have challenged.
It's not there cannot be any warrants, notice.
No, nothing, that is order passed, that is not come in the order. Only the respondent was given time to join. She is not willing, even your lordship was.
First of all, there is no execution for restitution unless at the.
I have not said anything with regard to
the condition, my lord, the order. It is a show cause notice. Type copy at annexure F, page number 49. It is in Kannada, my lord. 49, my lord, page number 49. It's a show cause notice. Since even in spite of.
What it says? What
it says, even in spite of several notice, since you are not appeared before the court, why disciplinary action shall not be taken against you? Disciplinary action. Shistu krama yake kaikollabaradu.
What disciplinary action?
That is, I don't know what disciplinary action should court wants.
Please come. The petition.
One request. Your lordship, kindly see the operation.
And another
operation of the.
And another.
But she remained expert. Despite their notice, she remained expert. And order, kindly see the order. And
another most important
so-called notice that has not come. Only thing is restitution of conjugal right has been ordered.
He is not questioning it. He is before this court questioning the order at notice at page number.
That is the question. That is the question.
Court cannot pass such an order. Court cannot issue such a notice. What disciplinary action court will take?
No. With regard to that so-called notice, let there be an order.
That is only I am passing, nothing else.
Restitution of conjugal has to remain.
The order, agreed with the notice. Show cause notice dated. What is the date? 25/11/2019. Whereby the trial court had. Where is it extracted in your affidavit or anywhere?
Petition. Para number 13, my lord, page number 6. It is submitted on 19/11/2019 at 10:40 AM. The petitioner was shocked to receive a show cause notice dated so and so issued by family court to the.
Where are you reading?
Para number 13, my lord, page number 6 of the petition. The contents mentioned in the show cause notice reads thus: the respondent in execution number 13/19 so and so.
Have issued a notice.
Refused to.
Stating that the wife had neglected the judicial proceedings in these circumstances, but disciplinary action should not be taken against her, and asked her to give an explanation before 25/11/2019. The husband has filed MC number 290 of 2018 seeking restitution of conjugal rights, and the same came to be allowed on 22/6/2019. Then the husband had filed execution petition.
Yes.
Then the husband has filed execution petition. In that, such a notice is issued by the court. The counsel appearing for the petitioner submits that for execution of a decree for restitution of conjugal rights, the court cannot issue such a notice stating that disciplinary proceedings will be initiated, and the said notice is contrary, entertaining the said application, and the said notice issued by the court is unknown to law. Next paragraph. Then counsel appearing for the respondent husband submits that the court, in spite of an order of restitution of conjugal rights, a decree that is passed, still the wife has not joined the husband, and the court has rightly issued the notice. And no grounds are made out seeking interference with the order passed. The notice issued by the court. Next paragraph. Having got the counsels on either side, there is the material on record. The notice on the notice that is included in this petition issued by the court is unknown to law. If a decree for restitution of conjugal rights is passed, and if any of the party has not complied with the same, and if he is a government servant, or in that case, at best, there could have been a petition for recovery for attachment of the salary, but there cannot be an order and a notice, no notice issued to the wife saying that why disciplinary action shall not be initiated against her. In view of the same, the order that is passed, the notice that is issued by the court is without jurisdiction, is contrary to law, and the same is set aside. Accordingly, petition is allowed.
No, prayer, kindly, prayer, there is no such prayer. Restitution of conjugal right has been allowed. That will remain, lordship.
That I am not interfering, Mr. Counsel.
The one line, warrant, kindly.
Why should it be?
Because by virtue of this.
Have you heard what the order of the court is saying? Have you heard the order, what is dictated? I said notice.
Yes.
I restricted the order to notice.
Yes.
So there is no further necessity for me to clarify. Yes, next matter.
To the extent of so-called notice, there is no.
I said only so-called notice.
Yes.
Don't have to say to the extent. Yes.
Public, sorry, madam.
Is 57? Yes, 58.
Lord, this is the husband's petition challenging the maintainability of the petition filed by the wife for recovery of maintenance.
Yes, where is that order? Court officer, 125(3) order. Read it, give it to her. This is matter tomorrow. This next. Next part.
Precious Naik, Bharti respondent. Precious Naik.
Representation. 16th of December. Yes, next.
Number 60. Shank Matapati. Shuraj Balwani.
Lord, 20,000 is awarded, my Lord.
Who?
So husband.
Who?
Lord, it is my case is that, Lord, on Lord, 2014, Lord, my wife, Lord, filed a divorce petition. It came to be, Lord, dismissed. But in the meantime, I filed a restitution petition, which came to be allowed. Now, Lord, 2017, a decree of divorce petition came to be dismissed. Once again, Lord, the divorce petition is filed, and the application is filed in the said petition.
So now, are you wife and husband or not?
Please. Earlier, the divorce petition from.
So two things. Are you questioning on the quantum or on the maintainability? What? Which one? Are you questioning that order on the ground that it is the amount is more, or that she cannot file a petition under 125?
24 under section 24 under section 24 of Hindu paragraph.
Not 125. In a pending MC.
My submission once already divorce petition. Once again, 2017 is dismissed, and once again 2018 of divorce petition is filed on the same ground, wherein an application was filed.
No, MC is pending.
MC is pending.
In the pending MC, she filed a petition under 24. For that, the maintenance is granted. Now, you are questioning the filing of an MC or filing of an IA.
Both.
How can you question the filing of an MC here? In a writ petition.
Even though when she herself left the matrimonial house, and she is not entitled to my case, because earlier order.
Who has decided it that she has left you? Any court had decided that you? In which case?
Number 75. 70 divorce petition were in the order 75.
But that is set aside. That is set aside, that order is set aside.
That is, my lord, dismissed, which is filed by wife. And my restitution petition came to be allowed. Even today also I am ready to take her back.
MC is filed by wife seeking divorce. What has happened to that?
That was dismissed.
When?
15 to 2017.
15 to?
2017.
And then what did you file?
In the meantime, I filed the MC 27 of 2015.
27?
From 2015 for restitution of funds.
What has happened to that?
It came to be allowed.
That is also allowed.
In spite of rejoining, my lords, after my lords, 1 second, my lords, she filed a divorce petition on the same ground, reality, which was already dismissed by the High Court. That my lords, judgment copy had produced.
Let's see what is on impugn order. Let us see.
75, page number 75. My lord.
No, not that order. Present impugn order.
The operative portion is at page number 58, the impugned order.
Yes.
I may request your lordship to kindly, that is page number 29, ink page 29. Yes, I may read from the second line. Have been, this is the affidavit which I filed in support of the application based on which impugned order is passed. Have been experienced many acts of physical and mental cruelty from the respondent. I have narrated them in detail in the foregoing paragraphs of the petition. The same may be treated as part and parcel of this petition. Since last week of October 2013, I have been driven out of the matrimonial house by the respondent, and in spite of judgment and decree in Hindu marriage petition number 27 of 2015 disposed of by learned senior civil judge Gadinglas, dated so and so, the respondent has not come forward.
He has a degree of restitution of conjugal rights. You have not joined him, and why do you simply say that he is not interested to join you? If he is not interested, why should you file? Why should he file a petition?
He is not interested, and he is not.
Now today, my lords, even today, tomorrow
Yes.
itself, I am ready to, my lords, get a
In this matter, but the parties are directed to present before this court on
I request for a short date, my lords.
21st.
Please.
21st. 21st in the chambers at 2 p.m. Yes, next.
number 6.
This is marked on 17 December.
17 December.
Yes.
Number 60. Reversal part.
The excise matter, madam, can you recollect? The rule 5 of the general condition rules.
Correct.
On last
File your
occasion,
objection.
that is before that only I filed it on last occasion, I made a wrong submission. The objection was filed on 10/10/2023.
What is your case?
The case is that, madam, it is a policy decision of the government. So it has been made as a one-time measure. So those only, if the objectionable place and the liquor license was existed on 1st July 2016, then only those things have been covered. If any subsequent thing is that, madam, it should be covered under section 2A, 5 subsection 2A.
So when have you established your
Since 2014, Your Lordship. Since 2014, I have been working.
According to you, it should be existing by 2016.
As on that date, if the license as well as the objection things is existed on same day,
on that day. Both should be existed. Then as a one time.
So if there is a license and all those prohibited, whatever it is, if they are in the next year, then that has to be considered. Then that 100 meters will apply then.
Please. Because in similar manner, when the National Highway Act was being, so some Supreme Court judgment, after that the policy was amended. As a one-time measure, that National Highway.
No, one-time measure is not this kind of measure. What is wrong today, how will it become right tomorrow? It is not some great, for the public you are doing something. If it is a cause for the public, court can understand as a one-time measure. Not for these kind of illegal things, a one-time measure. No, that prohibition, which is a basic rule when it is staring at you, how can there be a one-time measurement? Or that rule has to be amended?
But the only exception is if the both things should be existed in 2016. So subsequent for every renewal, Rule 5 is applicable. For example, after 2017, if the 2018 my shop is there, 2019 school or if something is established within 100 meters, that should be considered as objection thing, and because the on the.
What is it? 2000? No. When you are amending a rule, there will be some great object for amendment. So what is a great object according to as per the wisdom of the legislature or as per the wisdom of the executive?
They are telling because of the many representations are requested from the authorities. The union have requested, so therefore that has been done.
So during the last leg of argument, one major point skipped my mind. The date, Your Lordship, which I presented before this honorable court was, I have been running my shop since 2013. 2014, Your Lordship. I was shifted to the present place as on 13/7/2014. Then in the month of July 2020, the Office of District Minority and Welfare Office was established. July 2020. Before that, January 2020.
According to the rule, that prohibition, whatever the prohibition that's contained in Rule 4, will not apply if it is in the year 2016.
Yes, please, Your Lordship. If I was already established with a license as on July 2016.
It's not about you having a license as on 2016. It is about you should have a license as on 2016, and these things should also have come on 2016.
No.
If it comes after 2016, then again that Rule 4 applies according to that.
On plain reading of the
Let's
provision.
read it again.
Please, Your Lordship.
Where is it?
That in the compilation which I have given, Madam, the page 2 start with the. The page 1 start with the excise general condition rules, license rules, which govern the field, Madam. The relevant rule is Rule 5, Madam.
Yes.
Rule 5 subclass 1, which says what should not be there within 100 meters. The next page, Madam, it start with the proviso, that is amended proviso. The provided also that nothing in subsection Rule 1. Madam, the next page, Madam, page number 3, on the left side of the page and top of the page, Madam, next page.
Provided that there is sanction.
No, next page, next right side page. On the top of the, that is the provision which is amended. The provided also that nothing in subsection Rule 1 shall be applicable to the licensed premises located within the distance of 100 meters from the religious or education institution or hospital or any office of the state government or central government or local authorities renewed or existed as on 1st July 2016. So this is a provision under which the petitioner is claiming that.
So why should the court understand that even that whatever that the college or the school should be existing on that day? It doesn't say so. You say if something is existing as on 2016, for them no.
Provided that this is an exception to the clause 1. Please.
Shall be applicable to the, provided also that nothing in sub Rule 1, that is religious, educational, other things shall be applicable to the licensed premises located within a distance of 100 meters from any religious so and so, renewed or existed as on 1st July. So, what I can understand from a plain reading here, if you have a license as on 2016, so whatever that comes like later, whatever. Why about then? How do we understand this?
Clause 1 says what should not be there. This provision says my license is existed or renewed at place A place. With that A place, there was objectionable places. Then it is protected. Then the provision is not. Then the subsection 5 subclass 100 meters has no application. As existed or renewed or existed as on July 2016. So then 100-meter distance will not applicable if that the license which have existed at Mamigatti village. So that is a understanding.
Beyond comprehension. This rule is beyond comprehension. Not able to understand this. And he's trying to take advantage of it.
But if this rule is interpreted in such manner, then
that is non-est.
No subsection 4.
It is non-est in the eye of law. That rule 5. So you can't. There cannot be a proviso like to the exception to a proviso in this manner.
Only submission is that proviso which is exception as a one-time.
No, it is cart before the horse or a horse before the cart. That's how it is.
Maybe the reason is that this is a business relating to the liquor. It is not a fundamental right. So it's always on the directive principle.
And also, it's a directive principle of state policy. At the same time, you are also supposed to make the rules in consonance with the constitutional. Not like this, like arbitrary, whatever you feel like, you can't make it. And it is very strange. How it is.
If the rule subclass 5(1) and proviso and rule subclass 4, both are this proviso is contrary to rule 4.
No, one thing. No, have you coming to this? If your interpretation is taken to be correct, then this rule 5 need not be applied to any of the cases. Not only you, thousands of people must be having the license from several years, and whose license is is renewed and is there till 2016. If that is an interpretation given to this, then rule 5 need not be followed at all in all the cases. So wherever it is like this, so wherever there are old licenses, for them anything that comes in their way, or any religious or education institution, still their license should be there in the light of amendment. This proviso.
Is what the government's amendment says. As per the interpretation of the government, the submission made by the government is that the schools, colleges, so and so places, and my license should be existing as on 1st July 2016. But on the basis of the submissions of the government, the word used is existed, not coexisted. So if the submissions of the government have to be construed as true, the word that ought to have been used was coexisted. If the provision said that the temple or church or whatever was existing with my license as
we have to purposive construction we have to make. Whatever that interpretation should be purposive. Now, if what you are saying has to be taken into consideration, completely 5 should be removed from the rule book.
That aspect, I'm taking benefit of the act of the government, making fair submissions.
But that is true, but the court cannot at the same time that there should be a harmonious construction or interpretation.
In that case, Your Lordship, the previous existing rule 5 and the amended rule 5, if they are not in consonance, and it would be wrong on my part had I been on the other side. But now the government itself has made a provision to protect my business. A submission was made that a liquor shop does not fall under the ambit of fundamental rights. However, it is my livelihood. It is my business. So my humble submission is I am protected by the Constitution. Now I have been running this very shop since 2014. I have come here in 2016. Now this question of objectionable place within 100 meters did not arise, Your Lordship, till May 2023. May 2023. The schools and the office were established in the year 2020. However, right after the elections of Karnataka State Legislative Assembly, the divider, this area, this distance is measured by pedestrian pathology. For example, if I may illustrate, if a wine shop is situated there and there is a road and a divider here which runs for 5 kilometers and I'm situated right here, even if the distance from point A to point B is 15 meters, but if accessible on pedestrian path is more than 5 kilometers, that is permitted. This is exactly what the case is in this case here also. Now there was a divider existing in between.
No, here you are not on the question of what is the distance. You are on the point that this amended rule is in your favor.
Two grounds, Your Lordship. I'm relying on two grounds. The objections filed by the government at paragraph number 6, Your Lordship. If I may take Your Lordships to page number 3 of the objections.
Where are the objections? We'll continue tomorrow. Let's be on the top of the list. These remaining matters. 64. Any urgency? Huh? 63. Any urgency?
Please, my lord. Well, I have established the adultery during the pendency of the proceedings, my lord. So, trial court has passed the order.
This tomorrow. Is 64?
But 22 minutes. 22 minutes. Possible 22.
22nd.
Please.
Yes, this is not on 22nd. 64?
Interim order may kindly.
Interim order earlier granted is extended. Yes, 64.
Let's end open 64.
Lord, I appear for the petition.
No, any urgency.
No, Lord.
This is matter on.
Lord, there is the matter is infectious, Lord. Because the
Infectious. Main MC is disposed of. MC is disposed of.
Yes.
It is submitted that the main MC itself is
The
disposed
memo
of.
will be submitted tomorrow.
The main MC itself is disposed of and the petition has become infractions, dismissed as infraction. Yes, 65.
65.
No, next.
This is matter on 28 at the request of the council for the peace. 66. 66. 66. 66 on 11. This is matter on 11. 67. Huh? This is matter on 28. 68. What is any urgency? This is matter. This is matter on 11th of December. Intermodal, look at it. Intermodal is very extent. Next 70. Can we adjourn? This is matter on 9th of December at the request of non-council petition. Yes, 71.
71.
Can we adjourn?
The husband has agreed to pay 1 lakh. As it was discussed
tomorrow, 71 tomorrow. After that matter, top of the list. Yes.
Serial number 19 notes. Interim order was not extended.
Serial number?
19 notes. Morning notes.
Morning, it must have been already signed and went off. Look at it.
Serial number 19.
Super.